Good morning, everybody. I'd like to recognize Representative Woodcock for some remarks.
Thank you, Madam Chair. As of this morning, the United States has lost their fourth armed serviceman in the Iran impending war. I would ask that you start today with a moment of silence, please.
Sure.
Thank you.
Thank you. I will lead us in the pledge. I pledge
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
We'll open the executive session on CACR 24 relating to the right to educate children, providing that parents and guardians have a right to direct the education of their children. And I recognize Representative McDonald for a motion.
Thank you, Madam Chair. I move ought to pass.
Is there a second?
Second.
Discussion from Representative McDonald.
Yes, thank you. I'd like to move Amendment 0941H for an ought to pass as amended.
Is there a second?
Second.
Discussion, Representative McDonald.
Yes, thank you. Over the past couple of years, the legislative body has taken a very strong stance in upholding parental rights, and I think that is absolutely the direction we need to move forward in. A way to make that stronger is by putting that in the state constitution. I believe the prime sponsor of the bill in introducing this did a good job explaining why, and then afterwards a member of the public suggested that we change the word violated to infringe to make it stronger language, and I couldn't agree more. So that's exactly what this amendment does. You will see that beginning on line 7, it changes the word violated to infringe, and then again on line 19 on page 1. And that's the only change to this amendment. Thanks.
Anything from the second?
Only to say that I think that this is a very a timely CACR and amendment, particularly with respect to the change to the word infringe rather than violate for constitutional reasons, and in view of as we survey the landscape across the 50 states, we're seeing increasing threats to parental rights, most recently in the state of New Jersey. Thank you.
Any other discussion? Representative Murray.
Thank you, Madam Chair. I cannot support the ought to pass as amended, and I will speak to that because I think that even in the case of in loco parentis, which is something we all know, that when students enter into school, parents are not giving up rights when they are entering into the school system. They are working alongside of districts. So for that reason, I will not support the motion of ought to pass as amended.
Any other discussion? Seeing none, Madam Clerk, the motion on the amendment is OTP.
Vice Chairman Parental.
Yes.
Representative Terry.
Yes.
Representative Dry, yes. Representative Belcher.
Yes.
Representative Freeman.
Yes.
Representative Litchfield.
Yes.
Representative McDonald.
Yes.
Representative Tenzar.
Yes.
Representative Nadeau.
Yes.
Representative Cornell.
No.
Representative Murray.
No.
Representative Woodcock.
No.
Representative Hall.
No.
Representative Damon.
No.
Representative Selig.
No.
Representative Kluger.
No.
Representative Snodgrass.
No.
Chairman Noble.
Yes.
10 yeas, 8 nays.
Representative McDonald, do you have another motion?
Yes, ought to pass as amended by 0941H.
Is there a second?
Second.
Any other discussion? Seeing none, Madam Clerk, the motion is OTPA.
Vice Chairman Parental.
Yes.
Representative Terry.
Yes.
Representative Dry, yes. Representative Belcher.
Yes.
Representative Freeman.
Yes.
Representative Litchfield.
Yes.
Representative McDonald.
Yes.
Representative Tenzar.
Yes.
Representative Nato.
Yes.
Representative Cornell.
No.
Representative Murray.
No.
Representative Woodcock.
No.
Representative Hall.
No.
Representative Damon.
No.
Representative Selig.
No.
Representative Kluger.
No.
Representative Snodgrass.
No.
And Chairman Noble.
Yes.
10 yeas, 8 nays.
We'll close the executive session on CACR 24.
Report and ITL.
Representative Murray.
Okay.
We'll open the executive session on House Bill 1132, prohibiting the display of flags in public schools not authorized by law and establishing penalties for display of prohibited flags. And I look to Representative Freeman for a motion.
Thank you, Madam Chair. I move ought to pass.
Is there a second?
Yes.
Representative Litchfield. Discussion, Representative Freeman?
Yes, thank you, Madam Chair. Madam Chair, I'd like to introduce Amendment 2026-0767H, which added, for simplicity and because of some of the issues raised in the hearing, the word banners as well as school sports teams. One point was that regular Major League sports teams be included. After doing some research, I opted not to include that because I understand that some national sports teams can be tied back to certain gangs. So I believe this fixes the issues that were brought up, and I move to pass this amendment.
Is there a second?
Yes,
Any discussion from the second?
no further discussion.
Any other discussion on the amendment? Representative Woodcock?
Thank you, Madam Chair. Oh, thank you, Madam Chair. Just a question of the amendment maker. So under 1A, United States history classes, I would presume then I could bring in any flag or banner to use in that classroom as I was explaining slavery or gay rights or Black History Month or Cancer Month, anything that shows what occurred in American history. Is that how I read this?
You are correct, Representative.
Thank you.
Any other discussion? Representative Selig?
I am still reviewing the amendment and deciding about whether or not I support the amendment, whether it makes the bill any better, but I will certainly be voting against this bill because I view it as curbing free speech and violating the First Amendment. I think it's inappropriate to be saying just prohibiting display of any flags. I think that there's educational purposes to all flags, and I don't think that someone seeing a flag is going to be the impact of whether I certainly don't want to see swastikas in schools, but if it's part of a unit where people are learning about the impact of World War II and we need to display it so people know what it is and what its origin is, then there should be an educational purpose to it. But I don't think prohibiting flags based on political views and political ideation is appropriate, and I think it's a violation of the First Amendment.
Representative Hall?
Thank you, Madam Chair. This is a question of the sponsor. On line 17, officially representing the school, could we have a definition of that?
Thank you for the question, Representative. If some schools have their own school flag specifically for school-sponsored sports, so that's what that line intends to do.
Can I have a follow-up? Paul, again, of the sponsor. So if your school has exchange students, is that covered in here? Let's say if you have someone from Spain and they hang the Spanish flag, and they have, is that included in here, that it's allowed or not allowed?
If it's for instructional purposes, we're instructing the other students that we have exchange students, that would be allowed. Instructional purposes, and if you have an exchange program representative, then that's part of the instruction.
All right, thank you.
Thank you.
Representative Murray.
Thank you, Madam Chair. Yes, also a question for the Representative Freeman on the amendment draft. Regarding the penalties to educators and the superintendents, I'm curious to know whether or not, it says for the third violation and any other additional violation, the superintendent shall report the violation to the State Board of Ed. I'm curious to know between what else is there a monetary fine associated? I'm looking at 29 and 11 currently, but is there anything else? Because does an educator or a classroom participant, whoever is in violation of this, do they have access to their, whether it's their union representation or anything else in this process?
Thank you for the question, Representative. I would believe that they would have union representation, since it would be a penalty against an individual teacher, and as a part of that bargaining unit, they would have representation. So this would not exclude that representation.
Representative Cornell.
Thank you, Madam Chair. Another question for the sponsor. On the amended analysis on the backside of the page, it authorizes the State Board of Education to issue monetary penalties. Is there a schedule of what the monetary penalties might be, or how much it would be for different kinds of violations? Or is this just vaguely the State Board can issue monetary penalties up to their discretion?
Relative violations 18917C, 2C, not to excited. Representative, I'm not going to tell you I know the answer to that question. By making this up to $1,000, I would leave it up to the discretion of the Board of Ed or the DOE.
Representative Woodcock.
Thank you. For the maker of the amendment as well, I'd like to follow up on Representative Hall's question. Some of our school systems are made up of a wide culture of youngsters from multiple backgrounds. So when she was talking about a flag, say a Spanish flag for youngsters from the Dominican, from Puerto Rico, or wherever they have, Mexico, where we happen to have youngsters in our classes on a regular basis. It wouldn't be just for history class, it'd be on a regular basis. So does this allow then for have their country's flags in our schools?
Thank you for the question, Representative. Representative, if it's being used in an instructional manner, then yes, it would be allowed.
May I follow up, please?
Follow up?
It would be instruction. I mean, I go to that classroom every day. I'm in that school. I'm from a very mixed culture community that has a lot of youngsters on ESL and other programs from different countries. So if I have that country's flag for that youngster in the school, it's not, we're not doing more than like any other. Would that be, or wouldn't that would be acceptable?
I don't think anywhere in this bill that it says that isn't acceptable. What this bill says is it being used for instructional. If instructional means that you're educating the children in the classroom to the different geography, different flags in different geographical areas, then it would be allowed. Yeah.
Representative Litchfield.
Just a blanket question, but outside of instructional purposes, why is it necessary to have any other flags in the school or the classrooms?
I'll answer that if you may, because we have a lot of immigrants in our schools. We have a wide culture basis in our schools. We have kids from all over the United States, all over the world in our United States schools and in New Hampshire. So it's representative of their country in our schools.
Representative Litchfield.
So we can respect their cultural backgrounds while still letting them know that while in the United States, we have allegiance to the United States flag.
I'll let that go. Thank you.
Representative Murray?
Sure. I am also curious for everyone on page 1, line 26. The phrase perpetrator is used here as if it were in criminal court or some other context. I just wanted to be careful if we're, is the word perpetrator going to somebody's permanent record if they had a complaint lodged against them? That is something that for displaying a flag, I just wanted to make sure we're not moving towards some other conversation.
Thank you for the question, Representative Murray. No, we're not moving to another criminal.
Okay.
It has nothing to do with the criminal court, criminal charges.
Okay. Thank you.
Representative Selig?
Thank you. So I understand that the bill is addressing, it has an exemption for things used in instructional ways. And I just think about the high school where I used to teach, and we had our cafeteria filled with banners from different organizations, whether it was student government organizations, whether it was, student activities, whether it was flags from different countries, because our school hosted an ESL program for our district, whether it was about different things. So this bill talks about instructional spaces, but a cafeteria isn't necessarily an instructional space. So I'm trying to understand how that would get reconciled with this bill. Is it only instructional if it relates to a classroom? Does that mean hallways need to be free of these things unless they're the 3 flags designated? I'm just trying to get clarification on how that's going to work together.
Thank you for the question, Representative Selig. Can I ask you a question? Are you going to vote for this bill?
I don't see how that's relevant to my asking for clarification.
Sure. And I will give you the clarification, Representative, but if you are asking these questions knowing full well that you're not going to vote for this bill, then
Excuse me.
I can give you as much
Point of order. That is
clarification as you want.
inappropriate for the representative
You've already
to question
stated
my
that you wouldn't
Representative
vote for
Freeman,
this bill.
Excuse me. Point of order.
Enough. Representative Freeman, Representative Selig asked you a question.
Thank you, Madam Chair. As far as I can see, Representative, it would not exclude flags in the lunchroom presenting different countries.
Any other discussion? Representative Damon?
Thank you, Madam Chair. I wanted to respond to the question of why it would matter to have other flags than the ones allowed in this proposed legislation. I think many different kinds of banners and flags make a statement to whoever enters the space of welcome, of safety, of you belong here. And it saddens me greatly to think that we wouldn't want to provide that sense of welcome and safety.
Representative Litchfield?
I apologize up front for prolonging this discussion. I do have to say that in my children's school, we pay money for them to be in that school. And you know why we pay money for them to be in that school? Because there is zero activism, anything political. There are 0 flags anywhere in any of the hallways, in any of the lunchroom. It does not belong.
Any other discussion? Seeing none, Madam Clerk, the motion is OTP on the amendment.
Vice Chairman Parental.
Yes.
Representative Terry.
Yes.
Representative Dry, yes. Representative Belcher.
Yes.
Representative Freeman.
Yes.
Representative Litchfield.
Yes.
Representative McDonald.
Yes.
Representative Tenzar.
Yes.
Representative Nato.
Yes.
Representative Cornell.
No.
Representative Murray.
No.
Representative Woodcock.
No.
Representative Hall.
No.
Representative Damon.
No.
Representative Selig.
No.
Representative Kluger.
No.
Representative Snodgrass.
No.
Chairman Noble.
Yes.
10 yeas, 8 nays.
Representative Freeman, do you have another motion?
Yes, thank you, Madam Chair. I move OTPA on House Bill 1132.
Is there a second?
Second.
Any other discussion?
Thank you, Madam Chair. This bill just merely allows public and public charter schools to be neutral, welcoming communities for all students, staff, and visitors, no matter which race, religion, sexual identification, or personal ideology. All children should be in an environment that values them. This bill levels the educational playing field and brings down any barriers to an adequate education. Thank you.
Representative Selig.
To quote from the sponsor, all children should be welcome and all flags should be acceptable.
Okay, any other discussion? Seeing none, Madam Clerk, the motion is OTPA.
Vice Chairman Parental.
Yes.
Representative Terry.
Yes.
Representative Dry, yes. Representative Belcher.
Yes.
Representative Freeman.
Yes.
Representative Litchfield.
Yes.
Representative McDonald.
Yes.
Representative Tenzar.
Yes.
Representative Nadeau.
Yes.
Representative Cornell.
No.
Representative Murray.
No.
Representative Woodcock.
No.
Representative Hall.
No.
Representative Damon.
No.
Representative Selig.
No.
Representative Kluger.
No.
Representative Snodgrass.
No.
Chairman Noble.
Yes.
10 yeas, 8 nays.
And I'll be writing the minority report.
Representative Selig. Okay. Close the executive session on 11:32. We'll open the executive session on House Bill 1155 relative to the Home Education Advisory Council, and I recognize Representative Parental for a motion.
Thank you, Madam Chair. I move ought to pass on House Bill 1155.
Second.
Are you, okay, yes, never mind, sorry, my bad. My bad.
I would like
Okay,
to,
Representative Parental?
yes, I would like to put forth Amendment 2026-0878H.
Is there a second?
Second.
Representative Parental?
Thank you, Madam Chair. This amendment would repeal the Home Education Advisory Council. This council has had its day. Over the last several years, it has been a severely contentious council. They have had trouble approving minutes. It's taken 6 months to approve. It took 6 months to approve minutes from June. They had significant issues agreeing on an annual report. I have spoken with many people about the council. I have tried to find the historical
purpose, the legislative intent of this council, and there's a lot of romance surrounding it. People who like it because it had its place in the day. However, when I've tried to find people to come on the council to ease the animosity that takes place on it, no one is willing to step forth. And so therefore, I would move to repeal the council with this amendment.
Anything from the second?
Yes, thank you, Madam Chair. I just want to emphasize to anyone out there, anyone watching, this is not a reflection at all on the home education community whatsoever. This does not remove your voice. The home education community still has the ear of this committee and of this House. This is merely a time to end a commission whose time is over for now. Thank you.
Any other discussion? Representative Hall?
Thank you, Madam Chair. I didn't know much about this council personally until I heard all the testimony. And what I heard in testimony wasn't to repeal it. What I heard in testimony was to fix it, that to give power to school board representation, give power, let them vote. So I am not sure why after 30 years, we're just because there's contention that we get rid of it. So it makes no sense to me. I'm voting against this.
Representative Parental?
Thank you. In response to what Representative Hall said, the school board associations, the school administrator associations, they all currently are voting members of the board. My concern is the contention among the home education community that has arisen out of this council and has caused significant issues within the home education community. And for the good of the entire home education community, I recommend the repeal of this council.
Representative Murray?
Thank you, Madam Chair. And I'd like to say that I have all weekend been receiving comments, though I am not home educated any of my children, I understand. But listening to the voices of individuals who have reached out and are asking for this to remain and have some clarity around the Home Educators Advisory Council so that they can participate on either the rulemaking process and or the legislative process and have a voice at the table around that, I think is vitally important, and they are still seeking to have that connection. In addition to the named members of the council that you also noted, I think it's important for those folks who are trying to navigate home education as their preferred pathway, have an option like the council to be able to engage in that dialogue. And perhaps there is some clarity needed around getting like copies of the rulemaking register sent to them and things like that. So with that, I don't support the repeal.
Representative Hall?
Thank you, Madam Chair. This is a question of the sponsor. Who was it, refresh my memory, who was it that's not able to vote right now on that council?
The legislative members. The two representatives and the senator.
They follow up. Didn't we hear in committee, though, that the
original bill was repealing voting of power for some of the members.
Okay, thank you. That's why.
Any other discussion? Seeing none, Madam Clerk, the motion is OTP on the amendment.
Vice Chairman Petronell.
Yes.
Representative Terry.
Yes.
Representative Dry, yes. Representative Belcher.
Yes.
Representative Freeman.
Yes.
Representative Litchfield.
Yes.
Representative McDonald.
Yes.
Representative Tenzar.
Yes.
Representative Nato.
Yes.
Representative Cornell.
No.
Representative Murray.
No.
Representative Woodcock.
No.
Representative Hall.
No.
Representative Damon.
No.
Representative Selig.
Nope.
Representative Kluger.
No.
Representative Snodgrass.
No.
Chairman Noble.
Yes.
10 yeas, 8 nays.
Vice Chair Pedernal, do you have another motion?
Yes, thank you, Madam Chair. I move ought to pass as amended on House Bill 1155 with Amendment 2026-0878H.
Representative Belcher seconds. Any other discussion? Representative Selig?
Thank you. I just want to point out, having looked online, we had one person who supported this online and 366 opposed.
Any other discussion? Representative Pedernal?
Yes, would like to comment on Representative Selig's note about the number of online testimonies. There was definitely an opposition campaign that went out for all bills that were heard that day. That was a week ago today. And the recommendation was to sign in opposed to every bill that day. And so many of the names that I've seen on there, although there were a few who are from the home education community, many of them who I recognize were not from the home education community.
Any other discussion? Representative Litchfield?
Thank you. May I ask a question of Rep. Parental, if she is comfortable with that? Sure. So I've only had the opportunity to work with you for a few months. It's my understanding that you did homeschool. I'm just curious for how long and how many children?
20 years, 4 children.
Okay, and may I follow up?
Follow up?
So it's my understanding too that you are also the legislative appointee to this committee, and it is in your expert opinion that this is not supporting the homeschooling community at this point in time. It has not been helpful. There are other avenues we can seek. Is that correct?
Yes.
Okay, thank you.
Any other comments? That's a good question. Representative Selig?
Sorry, just Representative Paterno referenced that people who signed in were not necessarily people part of the homeschool community, but I'm just wondering, does that mean we need to discount their voices if they have feelings about state law? Shouldn't they be just as entitled to express their opinions as everyone else? Homeschool parents often comment about public school laws. In fact, many of them have written bills opposing public school. So I don't understand what the objection is to having public school parents comment against this bill.
I didn't say anything, I'm sorry, I didn't say anything about who these people were. I just know that there were names, particularly from my community, of people who I know for a fact have nothing to do with home education. And if you read some of the comments, some of the text that was submitted, it has nothing to do with the bill.
That is true. Any other comments? Representative Hall?
Madam Chair. I'll be voting against this. Again, I'm basing it on the testimony I heard from home education folks who wanted the council. So I'll be voting no, ITL, or voting no.
Any other discussion? Seeing none, Madam Clerk, the motion is OTPA.
Vice Chairman Paterno.
Yes.
Representative Terry.
Yes.
Representative Dry, yes. Representative Belcher.
Yes.
Representative Freeman.
Yes.
Representative Litchfield.
Yes.
Representative McDonald.
Yes.
Representative Tenzar.
Yes.
Representative Nato.
Yes.
Representative Cornell.
No.
Representative Murray.
No.
Representative Woodcock.
No.
Representative Hall.
No.
Representative Damon.
No.
Representative Selig.
No.
Representative Kluger.
No.
Representative Snodgrass.
No.
Chairman Noble.
Yes.
10 yeas, 8 nays.
Representative Hall? We'll close the executive session on 11:55. We'll open the executive session on House Bill 1268, modifying definitions and requirements relative to home education programs, and I'll recognize myself to make a motion of OTP.
Second.
Representative Parental seconds. I will introduce amendment as ought to pass. Amendment 2026-0887H. Is there a second?
Second.
And I will discuss. So for the last couple years, we've heard a lot of concern from the home educating community that because of EFAs, they fear getting caught up in further regulation. This is certainly a legitimate concern, as we have had to resist regulation of private education several times since I've been here, and we will continue to do so. 193A, home educating families want to be completely separate from EFA families. While they are already two separate pathways, the issue comes when talking about home educating. 193A home educators are unfunded, 194F homeschoolers are funded, and we call them homeschoolers because home education is actually a legal term defined in RSA 193A. Some 193A families do not like this perceived overlap in homeschooling. From what I could tell, this has really hit or seemed to hit a breaking point in the last 18 months or so, as some home educators got a little heated toward those who were taking an EFA. This seemed to spill into HEAC meetings, and then it just seemed to completely take control of HEAC. It's hard not to bring up HEAC when talking about this because it is from them that we have heard these concerns. Last summer, we met with some members of Grand State Home Educators, and I think a couple of members of HEAC were in that meeting. It was in that meeting where one of them had said that New Hampshire isn't exactly the freest when it comes to home education. And so naturally, this piqued my interest, and I started doing some research. It is true that we don't top any national list that I could find as being one of the best states for home education. This is when I had the idea to deregulate 193A, which would even further separate the two pathways because 194F homeschoolers would keep regulations. Right now, they have some similar requirements. In the event that regulations come back in the future, then maybe it would just be back to the way it is currently, rather than even further government intrusion, which was their concern. We also have a couple other bills that were aimed at making sure it's known that the two pathways are separate. Let's see. So I will go into explaining the different sections. Section 2, this has to do with equal access, and this is actually coming up in another bill. It will be the exact same language, so we can discuss this piece on that bill. Roman 2 is just saying that nothing in this section for equal access would require a parent to establish a home ed program that exceeds the requirements, and it adds the reference to 193A. In a okay. In section 3, it repeals and reenacts RSA 193A colon 1 to 5. In A1, we have the definition section. This is all pretty straightforward, but I'll just draw your attention to Roman 4 in the second sentence. And that says this definition shall not include a student participating in the education freedom account established in 194F, making it clear that an EFA student who is homeschooling is not the same as 193A home educated student. In A2 program established, we recognize that parents have the natural right to home education, to home educate their own children. In A:3, we have the optional declaration of home education. A notification will no longer be required unless you plan to obtain access to public school programs, or if you're in a public school and you're going to home educate, then you should let them know. In A4, several things. So, okay. I just want to look at the old amendment that we. Okay, so in the previous amendment, 0606H, under eligibility, Roman 1, a parent shall be eligible to establish a home education program for a child, including children with disabilities and developmentally disabled children as defined, and it lists the RSA. So some people did not like that. This has actually been in the rules for quite a long time. Oh, I'm sorry. Yeah. I'm so sorry. Page 2. Sorry about that. I'm like going from notes and amendments. So some didn't like that because they felt that we were singling out children with disabilities, but we had done some research, and our committee researcher had found that back in 1990, there was a proposed amendment to the homeschooling bill, and they were trying to exclude children with disabilities from being able to home educate. So I don't know for certain that's why this line ended up in there, but it's pretty logical that that could be one of the reasons. So I got some suggestions from some parents online who have children with disabilities, and they came up with some new language that I added. Where is that? So we changed it to a parent shall have the right to establish a home education program for his or her own child, regardless of ability, disability, developmental status, or educational needs. So everyone seemed to be comfortable with that new language. Roman 2 is language very similar to the current A4, and also Rule Ed 31504, I added the participation of the statewide assessment at the request of one of the homeschooling groups. Roman 3, that's from rules except for the employment and other activities. That is something new that we brought into this bill. That's on line 32, page 2. Roman 4 protects the student from data tracking. Roman 5 establishes the presumption that a parent is providing an education for their child, and the state can't use a participation in a home education program as evidence of failure to provide education or as a negative factor in assessing the adequacy of meeting a child's education needs. This doesn't stop an investigation, but it does shift the burden of proof from the home educating family to the state. Roman 6, DCYF or law enforcement shall not enter or inspect the home of a family without a warrant, a home educating family, without a warrant or without it being an emergency situation. And they also cannot use threats of foster care to coerce entry into a home or to get them to share records. Roman 7 protects the family from bad faith reports. Roman 8 protects the privacy of a home education program by requiring parental consent to be shared, information on their home education program being shared between agencies. Roman 9 makes it clear that if a home ed student enrolls in any other pathway, including an EFA, their home education program terminates. A5, so we're on line 30, page 3 now. A:5 is the optional certificate of completion. This was from the rules. I'm pretty sure it's been in there since 2014. The wording has changed to clarify that a parent may certify the completion of a home education program. This is happening now. It also allows for the parent to submit their certification to the commissioner, who will issue a certificate of completion of their home education program. This is also happening today and has been for quite a while. Not everybody does this. It's mostly kids that need it for the military, or I think they've done it for the police academy. Let's see, section 4 fixes a cross-reference to 193A in 194F. And it also adds that if a student has been accessing programs at their resident district as a 193A student, that parent should notify the school if their child enrolls in the EFA program. They are now an EFA student. Section 5 and Section 6 were just areas of law that OLS brought in to eliminate cross-references. Section 7 and 8 removes education as a finding for neglect.
What line was that?
I'm sorry, that was... So it starts on page 4, the bottom. Section 9, under rulemaking for 21-N:9, so this just clarifies what home study is. Some are concerned that this could be used as rulemaking for home education under 193A. Section 10 directs the Board of Education to repeal the Ed 315 rules for home education. Section 11 repeals the record keeping and the evaluation of home ed programs. So this bill is about putting parents in the driver's seat of their child's home education, but it's also about firmly setting the default position that parents do the right thing by their children. And I recognize Representative Parental for comments.
Thank you, Madam Chair. First of all, I would like to offer my sincere gratitude to Representative Noble for putting forth this bill. This is monumental for home education. In the time that I was home educating my own children, home education became more free in the state of New Hampshire, and that is something that I was really proud of, because it's really unusual for the burden of law to be reduced. And I was so happy that some of the burdensome requirements that we had early on in my home education years had been eliminated. For example, it was burdensome not only to me, but also to the local school district, because one of the requirements was photocopying the table of contents for all of the instructional material that we would use. And I'm not quite sure what they ever did with that in the superintendent's office, but I'm sure they were really happy not to have all of that paper sent to their office every single year. And back then we did have to notify every single year. So, and chances are when you're home educating, you know, you have a lot of leeway in what you want to do with your kids. And some of those tables of contents might not have been really pertinent a week or two later when you found out that your kids didn't like the book that you thought was perfect. So I love the direction that this bill is moving in. My role on this committee is to defend every method of education that parents choose for their own children. And that includes home education, utilization of an EFA grant, non-public schools, and public schools. And so I think that this bill really has taken into consideration what the members of the home education community have been looking for by further differentiating themselves from 194F. And by the way, home education is not explicit in 194F under as part of the part of the education freedom accounts. So this bill restores the rights to the parents, which is monumental. The disability piece on page 2, line 22, came specifically from testimony that was submitted to the committee. We did take into consideration some of the concerns and change the language there. Repealing the rulemaking is exceptionally protective of home educators because back in 2009 or 2010, there was some legislation that was a significant attack on home education. And when that did not pass, the superintendent at the time chose the backdoor approach to changing the rules behind the backs of home educators. And that is why eliminating the rulemaking authority is significant. I really, and the last piece with the removing educational neglect from the child protection statute, there have been cases where families are accused of educational neglect, but DCYF has no protocol for determining what that means. And to be honest, our education is kind of arbitrary, aside from teaching somebody how to read, write, and do math. In the public school system, we have to have a framework. We have to have a specific time frame of when students learn something because you have a lot of students to educate at one time. But the beauty of home education is that you can teach your kids how to read, write, and do math, and then learn whatever they want when it's necessary for them to learn it. And so it's hard to find what educational neglect might look like when people are learning based upon their needs. So with that, thank you, Madam Chair.
Any other discussion? Representative Murray?
Thank you, Madam Chair. I do have a couple of questions for you, given the drafted amendment that's before us, and I agree it's quite large. And so I'm curious. Throughout the bill, I know that you have defined parent to mean a parent or guardian or a person having legal custody of a child. But I just want to be clear that there are parts of this that I would have preferred children and family law to take a look over some of those things. But with regard to a legal guardian, they are not a parent in some circumstances, and they have very different rights enumerated to them. I know under, from personal experience of a family member who is dealing with that situation. So I just want to make sure that we are not muddying the waters there, because there are some things, for example, in foster care systems that require prior approval before changes or other circumstances can have if a child is placed in temporary or permanent custody with somebody else other than the biological parent. So that was the one question I had about how lumping that all together on page 2, line 12, how would that function with regard to this? Because they are not, in fact, parents in some circumstances. There is still a biological parent attached to that conversation.
Representative Parental, I would say that we do have people that have custody of children that are not their biological children that are still home educating. Would you agree?
Well, for example, adopted children are not biological children.
Madam Chair, that's my point. Sometimes it requires, especially in the event that there is a student who is being fostered from another state in a family, that there are requirements to notify and have other approvals granted prior to making a decision like home education. So it is not something that a parent can unilaterally, or excuse me, a foster parent can unilaterally make that choice.
Representative Dry?
Thank you. I'm reading it as the person who has legal custody of the child.
Yes. Representative Belcher?
Thank you, Madam Chair. I just hope to clarify a little bit on that one because I think the specific circumstances being talked to. So generally speaking, parent is going to be anybody who has a legal custody of a child, and that's kind of common understanding in jurisprudence. But the specific cases being referenced there, generally speaking, I believe those are going to be dictated by the courts or other people involved in that process. So they don't need to be, I think, set aside specifically in law because there's core process for dealing with making that adjudication.
Representative Murray?
That's precisely my point, and I think that I want to make sure that there is nothing, because sometimes those decisions, even getting a child's haircut, for example, might have to have a prior approval to get that done. So what I'm saying is that's not a fast decision sometimes, and that process takes a while. So while this is a very sweepingly large change, I want to make sure that there is nothing in here that is sort of putting that in conflict with children and family law. That's why I had mentioned that. My other question, if I may, sure. Madam Chair, is with regard to page 3, section 9, starting on line 27. And my question was, is there a time frame for how soon a parent has to notify an entity that their home education has terminated? Is it 10 days, 5 days, immediately following their termination?
Just to clarify, you're talking about page 3, line 27, Roman numeral 9?
Okay.
It's upon commencement of the actual program.
Right. So almost immediately.
They start.
Yeah, like simultaneously.
Okay.
Representative Woodcock?
Thank you, Madam Chair. I have 2 questions, 2 different topics in the bill, just my own clarity. I'm looking on the case. It doesn't matter, you, Kristen. On page 2, when we're talking about the, I understand the concept where if you're a home educated youngster now, particularly after all the dialogue we heard about the being concerned about educational neglect last week in the discussions, that under this bill, under this amendment, you don't have to report to anyone at any time that you're doing home education. And that's just presumed, and I'm looking at it as on line 2 or 3 on page 3, is you're doing it as presumed that you've met the law because you're doing it. Is that right? The way this is written?
Representative Parental?
Yes.
Okay, so that brings me back to the question then. How does the school system know that if you're, and I think look back on the page 2, if you don't ever have to tell the school? I'm not suggesting you do a thing with them, except say, I have one youngster and I'm homeschooling him, just so you know. It's just the fact that you're doing it, which is fine, if you're doing it, but how is anyone going to know that? Particularly we're listening to the folks concerned the other day about the neglect issue, and in the statement that if you're doing it, that satisfies the requirement. I got that. But I'm looking on the other side, which says you're not going to tell anybody. I'm surprised that that's, I think that was under line 11 on the other page too. But that's my point. My point is if I don't tell the school system or someone, you can even put it to deal with, I don't care who you are, just surprised, see my concern? No one's ever told you're actually doing it. And then so they just opens up the door to, well, why are they doing, what are they doing with the youngster? Not that you have to tell anybody, but you're presuming by the fact you're doing, you've met the need. I got that. But I don't understand how that's going to stop the issues we had before, or some people were testifying about, or educational neglect, because there's no way to verify it. So if I was going to report it, say to the school department that Steve Woodcock's not educating his youngster, he's just sitting home out back. They go to the school department, the superintendent says they're registered as a home educator. That's what you need. I find that, I don't know how you're gonna get around that. I don't know, Margaret looks like she has an answer. I don't know. I do see my confusion?
Thank you. You don't,
Representative
thank you. If you send your child to a private school, you don't have to tell the.
But the child school has enrollment. The child school has enrollment, has paperwork. And you wouldn't look at educational neglect because you could say, well, youngster goes to St. Michael's of Wakefield. But I don't know. I don't care. I'm just saying, it just seems to me that's going to be an issue because the people are concerned about the other day about the fact that you don't know where they are. That's all. That's not, I have another question to deal with that. I'm just raising that issue. That's all.
I see this as protective because other states have issued legislation that use that piece of paper as a trigger for an automatic DCYF or investigation into the family. And this is the protective mechanism. By not notifying, you are keeping DCYF out of your home.
There's also about 12 or 13 other states that don't have notification.
Okay, that's fine. And I don't see DCY going in. I think that'd be the answer. Just know if you register with the school department. Okay, now can I go to my bigger question?
Yes.
Okay, thank you. Michael's waiting. He may have an answer on this other one. Okay, thank you, Kristen. I want to make sure that I'm reading this totally, absolutely correct. On line 12 of page 1, and line 13, we're including now the phrase educational freedom account. And I did that, I'm assuming you put that in there because of the two pathways of home education with or without, right? But my concern is where we have line 13 and it says curricular courses, if I read that right, because there's a comma there, and it doesn't say home education account, kids who are home educated, it says educated freedom account. I would take that to mean perhaps that if I am someone who is receiving an education freedom account or a voucher, whatever you want to call those things, depending on what party you're from, I guess, that I'm getting $5,000, I'm sending my son to Brewster Academy, but damn, my school has a great physics class. So I'm going to allow him to go to my public school now, even though I'm giving him $5,000 to not go to public school. So that's my concern. I understand the whole bill's about home education. I get all that. I'm not trying to be a wise guy, but I think this really opens the door. It makes me nervous where it says EFA and there. And it has no other implication in terms of payment. Before, we used to have, if you recall, in some of the statutes, if you came to a public school for part of the time, or point 1, point 2, and it was reimbursed for that. But I see this could be, even though this is mostly dealing with home education, I could see that with those two commas and putting that out there as a singular piece, it would say to me, well, I can get my $5,000 and send my youngster to public school to take a course or two. Because it doesn't identify, and I understand that the intent of the bill is home education, but that's not how I read that line 12 or 13. And once again, the stuff you've done to open up home education, I have no problem with, Kristen. But that really concerns me because I'm not sure how that be interpreted. I'd really like to have either someone who has an attorney for either DOE or for someone who's an attorney look at that and tell us, because I think that could really open a door that I'd be really aggravated with.
So we actually have this exact same language in a bill that's coming up later. So that's why I didn't discuss it when I presented this bill, because we're going to get into all of that later. It's literally the exact same language. I just put it in two spots in case one doesn't survive.
So what does that mean? Tell me what that means.
Okay, I guess we're going to discuss it now. Yeah. So there was concern that education freedom account did not have equal access like non-public schools, like public charter school students and like home education students.
Right.
So all this does is add them as part of it. I don't know how, so public charter students are also getting adequacy, right? So that
The
is
school is,
about
right.
$9,000 that goes to the charter school
Well, yeah,
for that.
7,100, yeah, but it's a school.
So what I don't know is the district school charging that charter school student if they were to take a class at their district school?
I don't know that either.
So that is something that we do need to find out with this.
Well, so,
As of right now, it's just leveling the playing field.
may I? Madam Chair?
Sure.
If it's interpreted in a way it makes me nervous, I don't think we're leveling the playing field. Because what we're saying now is, if the way I'm reading this, that I'm gonna give you $5,000, and you can come back to public school. And yet, public school is only gonna get $3,700 if you're a public school student. This really makes it, because it's not clear and we have no legal documentation, this makes me really nervous. The whole homeschooling thing, I understand why you put it in there, Chris, and I have no problem with that. I think the homeschooling thing, you've done a great job, you and Kate, of opening this thing up. But I do have a real problem with seeing EFA in there and curricular courses in the same line in paragraph and stuck up there between commas, because it says to me that's a whole separate category.
Yeah, so
Unless it's, I mean, there may be,
they are doing this today. They are using EFA funds to take classes in their district schools today.
are they paying the district for that?
They are. And there are some that have an issue with that because we're allowing everybody else to do it for free.
So you're saying the EFA, based on what you're just saying now, man?
Yes.
But based on what you're saying right now, then, you're saying that the EFA people should be free as well as the homeschoolers, youngsters, and the charter school youngsters, and that's calling equal in the field. Okay, I don't see that as equal in the field, because charter school youngsters don't get any money that goes to the school. This EFA money is specifically for parents who've taken their youngster out of public school. They withdraw them, or except for 85% have never attended public school. But these kids have never been there, or they are there, and they're out. And that's why you're giving them money to supplement what they're doing. Okay. I don't want to be a dead camel, but I'm just saying.
It's adequacy, and adequacy is also going to the charter school for a student.
I'm not talking about the charter school.
And that's, I understand that.
That's a
but
public school.
These are people that live in town, they pay taxes.
I got that.
If you're giving the charter school
I'm not
student.
quoting, I understand your rationale. I just think that opens a whole huge door.
Representative Damon.
Thank you, Mr. Chair, Madam Chair, sorry, used to another committee. Following up on my colleague's discussion, I believe that there has been, but I can't recall the statute, a fee, 0.15, I think, per
Yes.
course, and there was a course number limit that non-public school students could access public school courses. So if we could find that to reference, it might be helpful to understand and see what the juxtaposition of the current statute is to this, because I would agree with my colleague that this could certainly be interpreted to mean that all of the categories listed on line 12 of students have access to all curricular courses in public schools at no cost. And that does not seem right to me. I would also say, if I may, that the folks from New Hampshire School Boards Association are in the audience and they have some information in terms of clarifying what we do or do not do in this regard, if we want to hear from them.
Yeah, Barb may know,
Not right now, no.
or Jim may know.
All this does is add education freedom account. This is current law. I did not write this. It already includes non-public, public charter school, and home educated pupils.
We understand that.
Okay, We will talk about this bill again. Representative Belcher.
Thank you, Madam Chair. I just wanted to briefly touch on both those items real quick. So what we're having, obviously, there's some, this is a policy issue, right? So there's some policy disagreement, I'm sure. But what has happened is on the first part, when it comes to the EFA students accessing local schools and whatnot, some schools and districts have been quite good. And they've set small fees to access it. However, some have not been so good. And they've set fees that in some cases seem to exceed EFA grant amounts to take a course or two or to participate in extracurriculars. So as a policy issue, some people in this room view this as a necessary corrective. Now, down the road, this may not be where we ultimately end up. Maybe we find a happy medium somewhere. But right now, this is, I think, viewed as a necessary corrective because some schools have taken what amount to punitive actions to prevent EFA students from accessing things like extracurriculars. And just to be clear, it doesn't give them full access to the entire program because once you take a certain number of classes in your local school, you're no longer an EFA student. You're now officially enrolled as a public school student. So it's not like 100%. I don't remember exactly what the number is, but it's far lower than that. To the other issue, there's been a lot of confusion in the community among people about this bill broadly and previous versions of it. I just want to summarize this. This bill represents a paradigm shift. Now, one of the fundamental things that American government was based on is the idea that you're innocent until proven guilty, right? We're not Stalin. We don't say, fine, show me the man and I'll show you the crime. That's not how we operate. But there are some rules and laws that have been put in place that kind of cast an askance glance at homeschool parents and kind of look at them like, well, maybe you're doing something wrong. And we just want to make sure in law that we retain 100% the assumption of innocence on the part of parents who choose to homeschool their own children. And we want to make sure that we're putting that in law. There's not going to be any investigations because you have a different view of something, as long as you're not violating the law and abusing your child, which would be a whole different thing and a whole different legal mechanism. You have the presumption of innocence. And I think that's really important because our system of government, the family doesn't exist for government. Government exists for the family. That's the building block. So we want to make sure that we keep things the right way around. Thank you.
Representative Woodcock.
Yeah, thank you, Madam Chair. Mike, I agree with you. The paradigm shift is fine, and I said that a gazillion times here. I can see what this has done, and it clarifies. I mean, after sitting through all that debate there a couple hours last week, I understand it's not clear, but it doesn't negate my concern about line 12 and 13. And I don't know if Attorney Four or Attorney Christopher back there could tell us legally, or if we have something to do. I just that makes me nervous. I mean, it really does. It seems to go all of a sudden that's in there, and it changes the whole dynamics because this is not home. That's not a homeschool student because it's put off by commas. So I really believe, and I'm not trying to kill time here because I don't want to do that, but I really believe that we need some clarity, legal clarity, and I can't find the statute either. I think Mike's right. There is a number on EFA kids in the reimbursement before the average daily membership is figured out for the 1 point, but I don't know what that is. But this makes me nervous.
Representative Parental.
I found it.
Oh, good.
Yes. Took a little bit. It's RSA 198-38. Roman numeral 1B. B as in boy.
Okay.
For the purpose of calculating ADMA, each pupil who is home educated in compliance with 193A and who is enrolled in a school board approved public school academic course in grades 7 through 12 shall count as an additional 0.15 pupil for each such academic course taken in a public school.
That's a home education.
We're,
What you're reading says home educated, you said.
yes.
Yes. Okay. That's my point.
That I'm just mentioning that's what we were referencing. We passed that 2 years ago. Yeah.
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 And there's nothing wrong with that. That's home education.
In a technical advisory from the department, having to do with this subject. It says under RSA 193:1-C, establishes 3 important protections for home educated charter and non-public school pupils that do not apply to EFAs. And then it has number 1, and it says equal basis for access. These students must be allowed to participate in curricular and co-curricular programs on the same terms as resident district pupils with no additional cost charged. Representative Murray?
Madam Chair.
Thank you, Madam Chair. Oh, do you have a question? I'm sorry, Representative.
Actually, I'd like to move the question.
Okay. Representative Selig. Oh, sorry, Representative Murray.
Thank you, Madam Chair. And I guess to that end, in just listening to what you had read on the technical advisory, it did specifically remain silent on the EFA program. It said not, but not including.
Right.
So I did, given the fact that the public taxpayer monies is deposited into that My Class wallet, and then that becomes, according to some, an individual discretion to how that money moves, but it is still public taxpayer money. So I am curious to know why we would go against a technical advisory that is there when they are specifically recommending that that stay separated. It says not to include EFAs.
We're talking about families who still pay taxes in their resident district. They still pay the local taxes, even though they receive the adequacy. And the technical advisory isn't statute. The technical advisory is issued based upon the statute. So we are trying to address this so the technical advisory can be simplified.
Representative Selig?
Thank you. I have a question not about this part of the bill, but specifically about page 2, lines 31 and 32. That says, notwithstanding any other law to the contrary, the hours and days set for employment or other activities for students shall not apply to home educated students. And what I'm curious is, does that mean that child labor laws that are specific that say that, for example, a 13-year-old can't work past 8 p.m. and a 15-year-old can't work past 10 p.m. would be waived so that they could work the overnight shift at, say, the chicken factory or other such things? And I'm trying to make sure that we're not, by the language included in this, subjecting those children to the types of things that currently they're protected against by child labor laws, or that we're not saying that those children could end up working 40 or 50 hours a week and trying to fit their home education around that. And so I just was hoping to get clarification about those lines and what the full implication of that is.
Representative Parental.
Again, that's left to the discretion of the parent, and I did have a home educating mother reach out to me, and that line in particular she was thrilled with, because her son, I can't remember where he worked, but it would have been beneficial to him for his future had he been able to work during daytime hours and then pursue his home education in the evening. It's not about child labor. It's about, oftentimes, home educated students get as much benefit out of their work experiences as they do out of their actual education. And being able to be flexible is one of the reasons these parents choose to home educate.
Sure. So basically, this is saying that all those laws that are designed to protect children from working more hours than they can work and also study would be waived for these students. Is that correct? That's what I seem to understand you're saying, is that those laws, I'm not suggesting children shouldn't be allowed to work during the day if they're home educating, but it appears that there's no structure to ensure that there's balance and protection for those children to make sure that they are in fact having the opportunity to get an education, rather than, for example, working at a supermarket 50 hours a week and then having very little time for anything else.
Representative Belcher.
Thank you, Madam Chair. I think I can offer just a little bit of clarification, because the word notwithstanding, or the phrase notwithstanding any law to the contrary, it specifically means that no law, federal or state, would be overridden by this provision. So any laws protecting child labor, including state and federal law, remain in full force and effect. This would only apply to things that are not in statute, like things like rulemaking and whatnot.
Representative Hall?
Thank you, Madam Chair. I just have a question for clarification on page 5, line 6, 7. I just want to make sure, so if and maybe I got it totally wrong. So if a family keeps their kids home to home educate them, but doesn't really educate them at all, the kids don't get any education, is this saying that that is not a welfare issue? That that's okay?
I mean, yes, this is saying that you cannot use education as a reason for a finding of neglect.
Okay, thank you very much.
Representative Selig?
So I'm not sure if we're coming up to the vote on this. I'm going to just request that we have an opportunity to caucus because I have some questions for my leadership prior to us voting on this. There are some things I don't fully understand.
Sure. Representative Damon?
So I have another question on page 3, line 14, 15. An anonymous report standing alone shall not constitute probable cause. It's statute that a reporter, a person who has concerns about the safety and well-being of a child may be able to report anonymously. So now we would be saying here, if I'm interpreting this correctly, that you may not make an anonymous report, that won't be adequate for the appropriate care of the child to be evaluated. I think that's very troublesome.
Representative Belcher?
Thank you, Madam Chair. Just to provide further clarity, the bill wouldn't do anything to prohibit anonymous reporting. That's kind of considered a cornerstone of quite a few different laws. However, in American jurisprudence going back a very long ways, an anonymous report is not considered enough to establish probable cause because a person has a right to face their accuser. So you can't establish, and probable cause is a legal threshold for things like search and seizure. So it could be enough to look at something, but it's not enough to, do searching and seizing and things of that nature.
Sure. Representative Damon?
Thank you. I appreciate the explanation, but as I read the full Roman numeral 6, lines 10 through 15, I don't think that that's what is stated in this proposed legislation. But pretty clearly says that you would not be able to enter in or inspect the home of a family engaged in home education based on an anonymous report. I think that's concerning.
Representative Parental?
It says without a warrant issued by a court.
Upon probable cause.
Yeah.
Madam Chair?
Representative Woodcock?
Yeah, you'll be surprised to hear this. I'm still worried about 12 and 13 on page 1. Is it possible that during the lunch break, you or the vice chair would contact DOE? We would get their opinion of that before we vote on this?
We can try to reach out to them.
I mean, we have, or a lawyer that knows something about how it's written.
Yeah, we can contact the DOE. Representative Murray?
Thank you, Madam Chair. I did also have a question regarding this is on page 3, section 6. And when they were talking about probable cause or genuine exigent circumstances, I went back and looked at the Fourth Amendment. I looked at state law. I couldn't necessarily find a definition for genuine exigent circumstances. Is that listed
It's an
somewhere?
emergency. It means it's an emergency.
I understand, but is there a definition for parameters around that? Is that enumerated somewhere in law as genuine exigent circumstances?
Representative Belcher?
Thank you, Madam Chair. So exigent circumstances are case law, so it's very clearly delineated from Supreme Court precedent. It's not something that we have in statute.
Sorry.
Representative Murray?
I thought that the chair was referencing exigent health and safety welfare circumstances. I'm sorry, I didn't think that it was referencing precedent in case law. So now I'm even more confused about which exigent circumstances you are referring to. Sorry, this is line 12 of page
Page
3.
3. I mean, I think it's just saying that you're not going to inspect the home of a family engaged in home education without a warrant with probable cause or unless there is an emergency situation. I thought somebody snapped. Any other discussion? Okay, just so you know, we have, like I said, we have a bill that has this exact same section.
I understand that if you want to recess this till we talk about that one, and then we can caucus on whatever we need to caucus on during the lunch break.
Are you caucusing on this amendment 887H?
Yes, I just have a lot of questions that I don't understand that I would like to ask my leadership about before we vote on it.
Okay.
And so if there's going to be other things that we're voting on that are very similar, that are likely to raise similar questions, maybe we should recess this, discuss those bills, and then we can caucus on those during the break to figure out how to do it. I am not prepared to vote on this without caucusing first, and so I don't know how you want to proceed.
Representative Belcher.
Thank you, Madam Chair. I just want to, caucus aside, because certainly we all have a right to have a caucus, but I just want to remind the committee that though the language is modified slightly from that section that was brought up, we did have a hearing in this committee and heard testimony on language that does effectively the same exact thing, just in a different bill. So we've already heard from the department, we've already heard from various organizations and from the public as far as the effect of some of that language.
Okay, if you want to caucus now, because we are going to vote on this amendment.
Madam Chair, I thought before we caucus, I don't know why we're calling, but I thought you, a minute ago, I asked you if we could get clarity from DOE or an attorney before we vote on this, maybe during lunch break, you said yes.
Like I said, we have the same exact bill coming up. It's got the exact same language. So we can discuss more then. 1817.
You already gavelled it.
Gavel it for recess. We're gonna go into caucus. no additional cost. These three. These three. Right. So we're adding the.
Are we all back? Not yet?
Okay, and we're back. Do you want to read that? What? I mean, or you want to see what they?
So during the recess, we reviewed the technical advisory from the Department of Education that is access to public school curricular and co-curricular programs. The date issued was 11/5/25. This addresses changes that came about in HB 10 last year, the Parental Bill of Rights. And on page 2 of the technical advisory, equal basis for access for EFA students. These students must be allowed to participate in curricular and co-curricular programs on the same terms as resident district pupils with no additional cost charged. So we're correcting a technical issue with this language in the amendment to HB 1268. In the technical advisory, it says the legislature did not extend to EFA students the same level of guaranteed access that applies to home educated charter or non-public school students under RSA 193:1-C. Our RSA 193:1-C establishes 3 important protections for home educated charter and non-public pupils, and we are correcting that inequality for EFA students in this language.
Any other comments? Representative Hall.
I do, thank you. I just want to say, this amendment, as I read it, first of all, I'm not anti-homeschooling at all. However, I think that all the stuff in here paints home education in a bad light. When I'm hearing like you don't have to educate your kids if you don't want to. I don't know. So I'm going to vote no on it.
This doesn't say you don't have to educate your kids if you don't want to. What it does say is you cannot use education as a reason for neglect. Now, there are people out there that actually think homeschooling is educational neglect. So that is why that's in there. Any other comments? Madam Chair, the motion is OTP on the amendment. Oh, sorry, Madam Clerk. Been on this bill too long.
Vice Chairman Parental.
Yes.
Representative Terry.
Yes.
Representative Dry, yes. Representative Belcher.
Yes.
Representative Freeman.
Yes.
Representative Litchfield.
Yes.
Representative McDonald.
Yes.
Representative Tenzar.
Yes.
Representative Nato.
Yes.
Representative Cornell.
No.
Representative Murray.
No.
Representative Woodcock.
No.
Representative Hall.
No.
Representative Damon.
No.
Representative Selig.
No.
Representative Kluger.
No.
Representative Snodgrass.
No.
Chairman Noble.
Yes.
10 yeas, 8 nays.
I would move ought to pass as amended on House Bill 1268. Is there a second?
Second.
And I have no further discussion. Representative Parental?
I think we've said all we need to say.
Any other comments? Seeing none? Madam Clerk, the motion is OTPA.
Vice Chairman Parental.
Yes.
Representative Terry.
Yes.
Representative Dry, yes. Representative Belcher.
Yes.
Representative Freeman.
Yes.
Representative Litchfield.
Yes.
Representative McDonald.
Yes.
Representative Tenzar.
Yes.
Representative Nato.
Yes.
Representative Cornell.
No.
Representative Murray.
No.
Representative Woodcock.
No.
Representative Hall.
No.
Representative Damon.
No.
Representative Selig.
Nope.
Representative Kluger.
No.
Representative Snodgrass.
No.
Chairman Noble.
Yes.
10 yeas, 8 nays.
Who's writing the report? Representative Murray. We will open the executive session on House Bill 1280, establishing a commission to study public school open enrollment. And I recognize Representative Belcher for a motion.
Thank you, Madam Chair. I would move ITL.
Is there a second?
Second.
We do have a minority amendment that we're gonna let Representative Damon discuss.
Oh, you'll do a lot of discussion.
Okay. Representative Damon?
Thank you, and thank you for allowing me to inform on its amendment number 0937, and you should all have it in front of you. I distributed it before we began this morning. Do have extra copies if anybody needs one. And the amendment was done by Representative Alboni, who is not able to be here today. It's responding to 3 considerations that were raised at the public hearing. So it adds to the proposed study commission on open enrollment an administrator appointed by the New Hampshire Alliance for Public Charter Schools so that their voices would be heard. We overlooked that in the original draft. The second thing it does is clarify the required report. The original bill language speaks of a summary report, which led to some confusion about if there's a summary report, is there more than one report? So that language is replaced with simply stating that the commission would provide a final report by September 1st, 2027, and listing who it gets distributed to. And the third and final change is in the amendment line 1617, it repeals the commission itself when the work is done, because as many of you probably know, we have a lot of inactive commissions still in statute for no reason, so it takes that out. I am happy to answer questions if I can. I think we've all heard a lot of discussion, both here in Concord and from constituents and concerned folks about open enrollment with the other bills that are pending. This, to me, is an approach to figure this out in a more comprehensive, thoughtful way. How could open enrollment benefit New Hampshire students and districts with clear implementation guidelines as opposed to the current uncertainties? Thank you.
Thank you. Are there any questions on the amendment? Representative Parental?
I have a question, and forgive me, I was trying to sort through papers. On the original bill, on page 3, section 2, lines 7, 8, 9, 10, and 11, there's a temporary suspension of RSA 194 D1 through D7. Does this amendment leave that in the original underlying bill?
Thank you for the question. Give me a second, please. Replacing all after. So, to be quite frank, I expected that the amendment was going to do what you just cited, take out line 7, 8, 9, but I don't think that this amendment does that. Replace after section with the following. Oh, no, I'm sorry. I misread. Yes, it does. It removes, because it's in the amendment, line 14 is replacing after section 1. So it's replacing section 2 with just all that remains is the repeal of the commission when the work is done. It takes out the suspension on open enrollment schools. So essentially it grandfathers in existing open enrollment programs. Sorry for the confusion.
It is written very confusingly.
That's true.
Representative Murray?
Thank you. Well, I don't want to speak to Representative Balboni's intentions. I think that she and a myriad of us who are here heard very intentionally that there was a desire to make sure that that sort of grandfathering was in there to be able to allow folks who are still currently enrolled in the program some stability while this was being undertaken. So yes, I was aware that that was in there because we had made some notes as to what those requested changes were.
Okay. Any other comments on the amendment? Okay, so we will get back to the ITL motion and recognize Representative Belcher.
Thank you, Madam Chair, and certainly while I appreciate amendments been drafted, I'll keep my comments confined to the bill and the motion as written, introduced. So, of course, while the bill does propose a study commission into the open enrollment issue, the most impactful, of course, part of this bill is the fact that it suspends any existing open enrollment agreements while that commission is doing its work, which would leave potentially quite a number of students in the lurch in the upcoming school year. Further, the language of the bill doesn't have establish a firm end to the commission. The difference between the two different draft reports effectively means that it would be at the discretion of the commission or require further legislation to repeal further down the road. Yeah, that's it for now. Thank you.
Anything from the second?
Did I understand that Representative Belcher spoke to the bill and not the amendment?
Correct.
Okay.
Yes, because the question is.
Then I'll do the same, so we're done. Madam Chair, I see the issue here as not being so much questions surrounding open enrollment, but the policy itself and resistance to open enrollment. And as far as, in addition, if there is a desire to study how open enrollment is working, then I would offer Prospect Mountain as a wonderful case study. It is working, and any inquiry with respect to how open enrollment is functioning and how well it is functioning, I would suggest that Superintendent Broderick would be more than happy to engage in that kind of back and forth and questioning about how open enrollment is working. Thank you.
Any other discussion? Representative Damon?
Thank you. I would just like to note that as the prime sponsor of this bill, I did not bring this forward in opposition to open enrollment. In fact, that's the first thing I said in my testimony when I introduced the bill. Open enrollment works quite well in many states, but their statutes are much more defined than what we currently have, and their funding mechanisms are very different from the New Hampshire funding mechanisms. So while we have a case study with Prospect Mountain of one arrangement in one small district, relatively small, that is not necessarily representative of the needs of all districts across the state. The background work on this bill was done by a considerable number of people across diverse school districts in New Hampshire who requested this help to make it easier to do open enrollment effectively. This is not an anti-open enrollment bill. Thank you.
Representative Murray?
Thank you, Madam Chair. And I think that this even, the bill before us further underlines some of the things that we're seeing play out live in front of us right now across town meeting days, and having this conversation about certain aspects of what open enrollment actually does mean in certain areas. And we've heard a lot. I agree with Representative Damon about the funding mechanisms are very different in other states that do have this, but we need to make sure that there is clarity. And we heard a litany of information from folks that had questions about what certain aspects meant, how they were to be interpreted. And so for that reason, I think we have kind of, in efforts to maybe look at even concepts like statewide open enrollment, we have opened the door so wide here that it is creating confusion among all sorts of folks as to how they proceed with those measures. So I would have preferred to have had the opportunity to bring the amendment forward and move forward that way.
Any other comments? Representative Selig?
Thank you. I just think if we are looking at making a major change to the way we're providing services to students statewide and different offerings, that we need to make sure we're doing it in a thoughtful, measured, careful way. And that what this 1-year commission, that especially with the amendment that has been offered but not presented, is that it gives us a single year to really have all of the different players review all the different things, identify what might work and what won't work, and look at ways that we could make this an equitable way to make this work statewide. We have very, very different needs for students, from Pittsburgh than we do from Oyster River. We have very different needs about the school systems in the different places and different ways in which people are able to fund their school systems. And the balance of things is likely, in my personal opinion, if we rush this process, to leave a huge number of children statewide without any schools and without the opportunity to access an adequate education without major barriers. Because if they are in, for example, Pittsburgh, and all the schools in their area close and they say, well, you can just go somewhere else through open enrollment, and they end up with a 2-hour drive to get to a school, we are seriously disenfranchising them and disenfranchising their families. And I just think giving our community, our state, an opportunity to be really thoughtful, really measured, makes much more sense than rushing through a bill that would otherwise force open enrollment statewide, as looks like we're going to be facing a vote later this week.
Any other comments? Representative Woodcock.
Just make a note that the concerns of Representative Belcher presented were addressed in the amendment. That was the purpose of the amendment after the hearing, because I think Mike at that time raised the concern on the open and closing dates. So the concerns that came up were addressed in the amendment. And I do believe that open enrollment is going to be part of the future. It'd be nice to have it well thought out and planned. Thank you.
Yep.
Point of order. I would request that when we're addressing other members of the community that we always refer to them as representative.
Thank you. Okay, any other comments? Madam Clerk, the motion is ITL.
Vice Chairman Parental.
Yes.
Representative Terry.
Yes.
Representative Dry, yes. Representative Belcher.
Yes.
Representative Freeman.
Yes.
Representative Litchfield. Representative McDonald.
Yes.
Representative Tenzar.
Yes.
Representative Nato.
Yes.
Representative Cornell.
Nope.
Representative Murray.
No on the ITL motion.
Representative Woodcock.
No.
Representative Hall.
No.
Representative Damon.
No.
Representative Selig.
No way.
Representative Kluger.
No.
Representative Snodgrass.
No.
Chairman Noble.
Yes.
9 yeas, 8 nays.
Who will write the report? Representative Paul.
CPA.
1334 will be next, and we're just going to take 5 minutes. We'll open the executive session on House Bill 1334, removing the authority of the Education Freedom Account Scholarship Organization to make decisions about certain educational expenses. And I look to Representative McDonald for a motion.
Thank you, Madam Chair. I move ITL on 1334.
Is there a second?
I'll second.
Discussion from Representative McDonald.
Yes, Madam Chair. House Bill 1334 repeals RSA 194-F:2, Roman numeral 2, subsection O. That very specific site removes like part of a sentence, which says any other educational expense approved by the scholarship organization. And that's on page 686 in the Blue Book, if anyone's wondering. And also on page 686 is subsections A through N, which specify very clearly what education freedom account dollars can be spent on, what is allowable by law. Section O is a catch-all for whatever else is included. The reason that I object to repealing that is the Education Freedom Account program is really designed to recognize that students learn differently. So it appeals especially to students that have different abilities or the disability community. And Section O particularly, I believe an unintended consequence of the bill would be harming that group of people. We heard from the scholarship fund during testimony that very few people have actually utilized this section. And because it's such a small number, it's hard to cite specific cases without getting into personally identifiable information. But the one that was brought up, it was a visually impaired student who his learning needs could be met under subsection O. And if this were repealed, if a future case were to arise, the same student wouldn't be able to get the tools they need for their education. So for those reasons, I move ITL. Thank you.
Representative Dry?
Thank you. For all the reasons that Representative McDonald said, plus the fact that if when you make a list, you kind of need an out at the end, or otherwise you're going to go back to statute all the time and revise your list.
Any other discussion? Representative Cornell?
Thank you, Madam Chair. I will be voting against the ITL because it is way too vague. When anything says any other educational expense approved by the scholarship organization, I think leaves it just way too open to interpretation, and I can't vote for something that just says any other. So I'll be voting it.
Representative Murray?
Thank you, Madam Chair. And to that end, I would say I understand Representative McDonald's point, but federal law already protects students under this circumstance where an assistive technology device or something other like that needs a student needs to have those needs met. However, it is my understanding that the Children's Scholarship Fund has certain notices to families that when they take EFA funds, there are certain things not available to them.
Representative Damon?
Thank you. Just asking Representative McDonald perhaps if she can provide more detail or clarification in the example that was cited of the visually impaired student. Because in reading A through N, I just am unable to contemplate what a student would need that's not included there. For example, L says educational services and therapies, including but not limited to, and then it lists a variety of therapies, but it's not limited. So, or the computer, hardware, internet connectivity, and other technological services and devices, there just seems to be all the options that would be necessary.
Yeah, thank you for the question. The scholarships fund said that it was a household item, and generally household items are prohibited, but in this specific instance, it was used for an educational purpose. So it really isn't specified in the other sections. It was an object that was tangible for the student to touch and feel. So in that instance, it was used as education, but generally would not be considered one of the other categories because it's a household item.
Thank you.
Representative Parental?
Yeah, and just for further clarification, which may or may not be clarification, but my notes read that specific items may be written into an IEP that might not be typically considered as educational items, and therefore they would qualify.
Any other discussion? Representative Murray?
Thank you. Thank you for the question. And if it's my understanding, and I remember the Children's Scholarship Fund doesn't have any obligation to adhere to an IEP, but could accept an IEP that is current or even expired. So to that end, I just wanted to also note that there are things within an IEP that may not necessarily be relevant to the student's actual current education.
Representative Belcher?
Thank you, Madam Chair. I just wanted to offer a little bit of clarification because, of course, federal law offering any protections for a student would not authorize the state to expend any funds. So the federal protections wouldn't necessarily apply. And to the same point, they may not apply at all, as we've heard, based on some disability and IEP findings, but that's a policy decision. That's not like a technical thing. We can make the decision right now that we think that EFA kids ought to be able to receive services or certain specific items for IEPs or other disabilities. And I think that's reasonable.
Representative Freeman?
Thank you, Madam Chair. A point of clarification, when the Children's Scholarship Fund came in front of us, they stated that this one particular item wasn't listed in any special education plan or IEP, and that this particular category is not for use by parents, but only by the program. And it's been used once in the entire continuum of time that the Children's Scholarship Fund has been running the CFA program. So for those reasons, I will be voting for this. Against it, I'm sorry. Oh my gosh, I had the wrong bill in front of me. Please, cold medicine, please.
Representative Murray?
Thank you, Madam Chair. And to that point, Representative Freeman's comments are well taken, and I think that it does concern me that if that, yes, I understand the option to utilize subcategory O was referenced as having only been accessed once, but then what would happen in the event that that were removed? And so to that end, even though it is an infrequent use, I'm not sure. As you mentioned, it was a scholarship. It is not available to the parents. It is for the scholarship organization in billing coding or, if you will, accounting coding. So I don't know that I'd want to take that away entirely.
Any other comments? Seeing none, Madam Clerk?
Motion.
The motion is ITL.
Motion is ITL. Vice Chairman Petronell.
Yes.
Representative Terry.
Yes.
Representative Dry. Yes. Representative Belcher.
Yes.
Representative Freeman.
Yes.
Representative Litchfield.
Yes.
Representative McDonald.
Yes.
Representative Tenzar.
Yes.
Representative Nato.
Yes.
Representative Cornell.
No.
Representative Murray.
No.
Representative Woodcock.
No.
Representative Hall.
No.
Representative Damon.
No.
Representative Selig.
Nope.
Representative Kluger.
No.
Representative Snodgrass.
No.
Chairman Noble.
Yes.
10 yeas, 8 nays.
Notes. Can I just note something? I did notice that a co-sponsor on this committee just voted for ITL, and he was a sponsor of the bill, and I don't think we even heard from him. I know it's after the fact, but I'm just making that statement.
It doesn't make.
That happens a lot, or has happened a lot this year, including myself.
Usually we hear why. In this case, we did not.
Well, if he didn't want to speak, he didn't speak.
Does anyone have 1358? I think it's an email, which I'm trying to pull up, but
The amendment.
to 1358.
Yeah.
Do you have it?
I don't know.
Cornell, do you have it?
I have, yes, I don't know why.
Oh,
I also have 17.
I don't have the paper version.
I lost my last
Hey, you.
one.
I don't have a paper copy, I guess.
More of these, we're short.
1358.
No, we were not short. Yes, we are short.
0924?
Yes.
13.
Here comes, 0915.
I'll just work off some counties. I guess so.
This is more of 1358.
This is a different
Yeah,
one.
no, down there they don't have it. I don't get too far, but first I just have.
They're definitely here.
Here you go.
We'll open the executive session on House Bill 1358, establishing a commission to study transitioning all public schools to public charter schools, and I recognize Representative Parental for a motion.
Thank you, Madam Chair. I move ought to pass on House Bill 1358.
Is there a second?
I'll second that.
Vice Chair Parental.
I would like to put forward Amendment 2026-0924H.
Is there a second?
I'll second that.
Vice Chair Parental.
Yeah, so Amendment 0924H, the first thing that it does is eliminates page 1 of the original bill, all of section 1. That has to do with converting, how you would convert a current public school into a charter school. So we're eliminating that section and just keeping the study section of it. And I made some changes to the members of the commission, and that's all. Those are the only changes. So 3 members of the House of Representatives, 1 member of the Senate, the Commissioner of the Department of Education stays the same, 1 representative of a public charter school, and 1 representative of a traditional public school district. And we kept it small, knowing that at any point in time, the commission could bring in any experts they wish to have testify on this commission. And I'll speak to the underlying bill. In addition, public charter schools are funded. They receive a significant amount of adequacy. They receive the same adequacy that public schools receive, and they also receive additional funding to the amount of about $9,000+ per student. Charter schools have a significant amount of local control. They depend upon a board and parents to support their charter. And I just think this is something that's an interesting topic and worth looking into to see if this is a way to possibly transition some of the issues that we have going on. Certainly doesn't put anything into action. It's just a matter of studying it. And oh, sorry, one other thing that I did was the commission will be, it will sunset on November 1st, 2026. This year.
So if it doesn't get signed into law until July, this would give them like 3 months?
Yeah.
Representative Freeman.
I have to reiterate exactly what Representative Parental said.
Any other discussion? Representative Hall?
Yeah, thank you, Madam Chair. I have a question. Let's say line 3, when it says to study transitioning all public schools to public charter schools, all, is that what it means? Like, to get rid of public schools? Or make them all?
Charter schools are public schools, so it wouldn't be eliminating public schools.
And can I follow up? So what does that do when we're supposed to provide adequate education for public schools? What does that do?
I think that's what the study would determine.
That's the intent. Okay, that's what I thought. Thank you.
Representative Murray?
Thank you, Madam Chair. And I will have to say that both in the initial underlying bill and the proposed amendment, there's still, in my opinion, a wholly inadequate group of public education, traditional public school membership. That is the largest cohort of individuals who attend a school throughout the state of New Hampshire. And I understand Representative Parental's point to say that they could bring forward any number of individuals, but we've seen in other committees that have been brought before us through legislation just even today that committee compositions regarding public schools were broken up even by county to ensure that there were a broad spectrum of public school individuals on a committee or a commission. And so when we're talking about a large change such as this, I really am concerned for the lack of there being a representative of traditional public school and it just being limited to one.
Representative Damon?
Thank you. I have two remarks. I note that in the amendment, the change in presentation of the members of the commission removes the specification of majority party and minority party representation for the House representatives. And I think that's unfortunate. It could create a rather less diverse viewpoints on the commission, and that seems problematic to me. And then I would note, and I'm saying this in part having sat on the study committee on SAU consolidation this fall, which had also a very short timeline to complete the work and report out. This is an enormous task and responsibility to evaluate the possibilities. I find it completely unrealistic that the members of the commission would be able to do this in the timeline that's specified in the bill and do it thoroughly in that timeline. It just doesn't seem adequate to do a good job.
Representative Woodcock?
Thank you, Representative Noble. I think this amendment presented by Representative Parental, it scares me. It scared me when I heard the original bill. It scares me when I made 3 pages of notes. And it scares me even more now for a couple of reasons. I have reluctance with charter schools and I love the thematic approach. I love the things they do. We have 2 in a town I live in, and they're totally different, serving totally different populations and a totally different result because of different populations. That being said, where I have a concern is the reductions in some of the safeguards we have, particularly when it comes to licensure and teaching teachers in the charter schools, where we only need 50% of teachers in a charter school to be certified or licensed by the state of New Hampshire, and even less than that if you use their opt-out with that 3-year opportunity. That to me does a couple of things. It scares me that we aren't going to be training people to be teachers in certain areas, and we only need half as many. I'm not suggesting that you need a degree to be a good teacher, but I'm suggesting you have to somewhere learn the tools besides being just that. So this, just even opening the door to thinking that every school would be a charter school, and the originator said last week, if you recall, Representative Osborne indicated, I think his comment was, like quoted down here, that, well, if parents don't like the way the charter school is going, they can go leave aside another one. Well, I mean, that's even worse. So I don't even like the damn concept of thinking all public schools that serve 160,000 kids can be converted into areas where there could be people who aren't even qualified to teach, be responsible for their education. Thank you.
Representative Freeman?
Thank you, Madam Chairman. I can understand Representative Woodcock's concerns. However, this is a study committee. What's to say that the committee finds that trying to convert all of our public schools into public charter schools is too big of a job, too tenuous, too many regulations, just not worth the effort? It's a study committee. We want to put study committees in place because we don't have all the answers initially. A bill to convert all of the public schools to public charter schools would have me concerned as well, but that's not what this is. This is establishing a commission to study transitioning all public schools to public charter schools. And I heard what Representative Damon said about the commission she was on and how that did not have enough time. That very well may be true with this as well, but it's a study commission. It's not putting any laws in. There's no legislation attached to it. It comes out with their recommendations. So for that reason, I'll be supporting this because I would like to see where and what this particular commission would be able to come up with.
Representative Selig?
Thank you, Madam Chair. I just will reiterate the point I made on a previous bill. If we're looking at making a massive dynamic shift in how we provide education to the children across the state, it should be done in a careful, thoughtful, measured process, which takes time. And so, you know, I would have been slightly more amenable to this if the timeline was to 2027, but it seems to me that by putting a November 1st, 2026 timeline, the intent here is to rush the process and make it very difficult, just like the hearing had such short notice, giving such a short timeline for people to be able to contribute creates raises serious questions for me about truly valuing the voices of the people of New Hampshire and making sure we're ensuring things are studied in an appropriate fashion.
Did you have something to say? Representative Parental?
The purpose of the original bill had the committee ending on January 1st, 2027. That's only 2 months after.
I would have gone to November of 2027.
Right. However, we're in an election cycle. So the study would begin, and then there's a possibility that any of the members would be replaced. And it takes time to appoint new members to the study committee. So therefore, we're ending it before the election.
Any other Representative Damon?
I just have an observation that it's extremely uncomfortable to me to have 1280 opposed a study commission on very significant changes in New Hampshire education process. And now the folks who didn't support that embracing this study process. It's quite perplexing to me.
Representative Dry?
Thank you, and thank you, Representative Damon. That's the reason here, because the previous bill was 24 or 25, depending on the amendment, members of the commission, and this is down to 7. And I feel personally that I like the smaller number, bringing in people rather than trying to work in a commission that's that big.
Representative Murray?
Thank you, Madam Chair. And to that end, I am also, the charges of the commission, I think we did talk about at length how there are many of them, and whether or not we could comport with getting through all of them is one concept. But the other area that I am concerned about is that some of these are prescriptive to sort of get to an end result that isn't necessarily examining whether or not it is feasible, but comes up with the final result being predictive, like reducing reliance on local property taxes while increasing a state level funding support, or considering how a transition charter-based governance could increase local district flexibility. Charter school board governance is entirely different from local school boards who are elected. So some of them are even corporate entities that have members of corporations that are on those charter school boards. So they're not apples to apples conversations.
Any other comments? Seeing none, Madam Clerk. The motion is OTP. Oh, sorry.
We have to adopt the amendment.
Yeah, on the amendment.
Vice Chairman Parental. Yes. Representative Terry.
Yes.
Representative Dry, yes. Representative Belcher.
Yes.
Representative Freeman.
Yes.
Representative Litchfield.
Yes.
Representative McDonald.
Yes.
Representative Tenzar.
Yes.
Representative Nato.
Yes.
Representative Cornell.
No.
Representative Murray.
No.
Representative Woodcock.
No.
Representative Hall.
No.
Representative Damon.
No.
Representative Selig.
Nope.
Representative Kluger.
No.
Representative Snodgrass.
No.
And Chairman Noble.
Yes.
10 yeas, 8 nays.
Representative Parental, do you have another motion?
Yes, thank you, Madam Chair. I move ought to pass as amended on House Bill 1358 with Amendment 2026-09248.
Is there a second?
I'll second that.
Any discussion, Representative Parental?
No, I think we have
Okay.
heard everything we need.
Any other comments?
No, thank you.
Seeing none, Madam Clerk, the motion is OTPA.
Vice Chairman Peternell.
Yes.
Representative Terry.
Yes.
Representative Dry, yes. Representative Belcher.
Yes.
Representative Freeman.
Yes.
Representative Litchfield.
Yes.
Representative McDonald.
Yes.
Representative Tenzar.
Yes.
Representative Nato.
Yes.
Representative Cornell.
No.
Representative Murray.
No.
Representative Woodcock.
No.
Representative Hall.
No.
Representative Damon.
No.
Representative Selig.
Nope.
Representative Kluger.
No.
Representative Snodgrass.
No.
Chairman Noble.
Yes.
10 yeas, 8 nays.
Who's writing the report? Representative Murray?
Murray?
Once this bill is wrapped up, I was wondering if we could consider a 5-minute caucus, please.
After this bill. Okay.
After 1358.
Oh, right now then. We're done.
Yes, please. Okay, I just want to make sure.
Okay, we'll take a 5-minute caucus.
Oh, you know how much. Tell me what I think, Carl. They've all been tempted. 1289. His hand stepped out.
Everyone have the amendment
Oh my gosh.
1374, 1774.
1774. We will open the executive session on House Bill 1374 relative to the procedures for withdrawal from a cooperative school district, and I look to Representative Litchfield for a motion.
Yes, Madam Chair, I'd like to make the motion of ought to pass on House Bill 1374.
Second.
Okay. Any discussion, Representative Litchfield?
Yes, please. House Bill 1374 amends RSA 195 to clarify the procedure for withdrawal from a cooperative school district. Under current law, even if a majority of voters in a withdrawing district support departure, the broader cooperative district may effectively block that decision. This bill places the decision with the voters of the withdrawing district, requiring approval by a 3/5 supermajority of those present and voting. The legislation retains important protections. The State Board of Education must approve the withdrawal plan prior to submission to voters, and the plan must address the equitable distribution of property and the assumption of liabilities. By maintaining a supermajority threshold and State Board oversight, the bill ensures that withdrawal occurs only where there is strong local consensus and a sound financial plan. HB 1374 strengthens local control while preserving accountability and statutory clarity. For these reasons, the committee recommends ought to pass.
Representative Belcher? Any other comments? Representative Selig?
Thank you. I will be opposing the ought to pass. There's some questions about the Articles of Agreement, about some different opportunities and ways in which this process could happen. It can be incredibly disruptive to a school district to have one town suddenly decide to leave without an appropriate timeline and without a plan. And, you know, I am very much part of a cooperative school district. We see the benefits of having children from a variety of different backgrounds at our school and how it widens perspectives and understanding of a number of issues. And I think that the way that this bill is written is really detrimental, especially to smaller communities and small towns that need, that couldn't afford to necessarily have a school district on their own, but work within that cooperative model to be able to make all of them work together.
Representative Murray?
Thank you, Madam Chair. And yes, I also would say that I am having trouble understanding. There's a couple things I'm concerned with. One of them being the terminology about withdrawing as soon as may reasonably be possible at an annual special meeting or special meeting. And so that sort of vague language, I don't know where that, you know, who determines what's reasonably possible. In addition, I think there was some conversation about distribution of assets, and I could foresee if this was to move forward as it is presented, this could be potentially litigated for a while to determine when those assets would be distributed and how. So I worry about that on behalf of taxpayers and voters as well in a cooperative district.
Any other, Representative Damon?
Thank you. My rep district, which is half of Sullivan County, includes towns that are parts of two different cooperative districts, one of which is a 5-town district, Fall Mountain, that currently has 2 towns separately voting on withdrawal next week. The potential property tax impact on the remaining towns, if either, but especially if both of those towns withdraw, is between a 20 and a 40% property tax increase. I think making it easier for towns to withdraw from cooperative districts is a very serious concern, and I am not in favor of this bill.
Representative Freeman?
Thank you, Madam Chair. I'd like to turn my fellow committee members' attention to page 2, line 8, where it says, if the state board approves the withdrawal plan, whether submitted by the committee or by minority report, the plan shall be submitted to the voters of the withdrawing school district in accordance with RSA 195:29. So it appears to me that there are some safety nets in this where it would not be a huge sudden change for any of the cooperative school districts. I'll be voting for this because I do believe that as long as the voters want it and the state board approves it, and it meets the metric to not create a substantial hardship on any other of the remaining towns in a co-op, I think this is what local control should look like. Thank you.
Representative Damon?
Thank you. If I may, in the example that I just cited, the state board did approve the withdrawal plans for these two towns, despite the property tax impact on the remaining towns in the cooperative. So I don't consider that an adequate safeguard. Separately, I would also note at the beginning of the bill, so on page 1, line 4, where it says the withdrawal plan to be published once in some newspaper generally circulated within the cooperative school district. As I think all of us are aware, there are fewer and fewer newspapers, and that is not an adequate, independently adequate communication. I think at a minimum, it needs to be more widely publicized on all the school district websites and communicated more adequately.
Representative Murray?
Thank you, Madam Chair. I agree. I recently just heard from a myriad of other communities that shared with me, to my surprise, access to internet issues as well as a lack of a local newspaper. So with that, I am curious to know how this would move forward. If there was a cooperative school district that had no newspaper, where would that fall?
Okay. Representative Dry?
Thank you. I totally understand that point, but I think if we read the entire paragraph, then it is the school board of the cooperative district's duty to start to call a special meeting, either an annual meeting or a special meeting for the purpose of discussing it. So I think that they would do their best to do that, but they also have a responsibility to put things around, which I think is in their best interest.
Any other? Representative Litchfield?
I just wanted to share something that I think is kind of ironic. I just brought this before the municipal and county government, and it actually, the bill just got killed. But it was brought to me by our zoning board because they were concerned because there were inconsistencies in the law with the zoning board has to utilize the newspaper. And it was the press association that actually came out and spoke against it and said, no, we want this to continue to be in the newspaper. Based on my experience with the boards, our town, our district is 6 towns. They would most definitely advertise something like this. And as I stated before, probably not the best analogy, but it just makes me think of a marriage. So if everybody doesn't agree, then one person has to stay in a bad marriage. It's just not fair.
Representative Murray?
Thank you, Madam Chair. I think the broader discussion of when we're talking about newspapers generally being circulated, are we talking about digital circulation, in paper circulation? Are we also talking about whether or not this is something that folks have easy access to? And I wholeheartly agree with the concern Representative Damon brought forward. I would encourage members to continue to post things in a myriad of areas. At least 3, which has been the standard elsewhere, for other types of changes that require a 3/5 supermajority. And to that end, I think, I am concerned for the tax burden to have folks, in the middle of the year discussing this next week. Yeah.
Vice Chair Parental?
The newspaper's current statute, that's not something that was added with this bill.
I understand it.
Representative Selig?
Thank you. To Representative Litchfield's point about, when people are engaged in a bad marriage, they can end the marriage. But if there's serious financial inequity between the two partners in a marriage, the courts will work it out in a way to try to ensure fairness for both parties. That's a different process than separating a school system where you may have a cooperative school system made up of wealthier towns and smaller towns and poorer towns where the cost is distributed in a way to be balanced and fair. Or like my district where my town is the largest provider of children and also money to the district. And we have 2 smaller towns that feed into it. And costs are divided proportionately to make sure that it's more balanced. The separation, just because one town decides it doesn't want to be part of it, doesn't this doesn't address any way to ensure financial equity. We currently are paying off a middle school. We got an incredible rate on our bond, but it's a 30-year note on the bond. And even at 2%, it's still 30 years that we need to pay that off. If one of the towns withdrew and suddenly that burden was placed on the other towns without that town that voted in favor of it having a share of the burden, there's no balance in that, in this bill, the way it's written. And so there needs to be some component that demonstrates a way, if a town severs the relationship, that if there's longstanding debts that have been incurred based on the voters in the district, that those debts should be split still amongst the towns that voted in favor of it. It's not done in an equitable.
Representative Belcher?
Thank you, Madam Chair. I just wanted to briefly comment that I want to go on the record and say I, for one, have no concerns that any district that might find itself possibly on the losing financial end will have any trouble advertising and trying to drive out vote. That's not something I've ever seen, ever. And the whole point of this is you get these agreements that are enacted at a certain time and place with certain circumstances. Things change in time, and incentives can tilt toward one way or the other over time. So there has to be some mechanism in place to alter agreements over time so they don't become more and more tilted in one direction. And I think that's just what this is trying to achieve.
Representative Litchfield?
Thank you, Madam Chair. Two things that I wanted to bring up too. I can appreciate what you're saying, Representative. It's just many of the districts that I've heard that are trying to exit these cooperative agreements actually have to do with the finances, and they are being outvoted by the larger communities having to fund these larger expenditures, whether it be renovations or new buildings or anything along those lines. So that's the first thing. And then the second thing, I think you're absolutely right about getting the vote out. I think that's shown as far as even our hearings here are concerned and those that sign in are out. I think plenty of media attention is getting out there. Thank you.
Any other comments? Seeing none. Madam Clerk, motion is OTP.
Vice Chairman Parental.
Yes.
Representative Terry.
Yes.
Representative Dry, yes. Representative Belcher.
Yes.
Representative Freeman.
Yes.
Representative Litchfield.
Yes.
Representative McDonald.
Yes.
Representative Tenzar.
Yes.
Representative Nato.
Yes.
Representative Cornell.
No.
Representative Murray.
No.
Representative Woodcock.
No.
Representative Hall.
No.
Representative Damon.
No.
Representative Selig.
Nope.
Representative Kluger.
No.
Representative Snodgrass.
No.
And Chairman Noble.
Yes.
10 yeas, 8 nays.
I'll be writing the minority report.
We'll close the executive session and we will be back at 1:45. All set? We will open the executive session on House Bill 1401, amending the meaning of scholarship organization as it pertains to education freedom accounts, and I look to Representative Belcher for a motion.
Thank you, Madam Chair. I move interim study.
Is there a second?
Second?
Discussion from Representative Belcher.
Yes, thank you, Madam Chair. Well, I don't necessarily have a problem with the idea of open bidding up to get more competition involved. I do have a little concern over the broad language. It seems like very broad rulemaking. And I would like to, just from my own perspective, I would like to maybe look for an advisory opinion or something of the sort from the courts to see what they have to say about it before making any changes. So I think we should study this. Thanks.
Anything from the second?
Only to add that there were, I think, significant questions raised, and they were not answered completely or accurately with respect to Odyssey and other potential groups that might be interested. So I think this is one of those instances where more work is needed.
Any other discussion? Representative Murray?
Yes, thank you, Madam Chair. Correct me if I'm wrong, is this not also the bill that we received email communication from Nate Green on about whether or not there was a question about one or more of the scholarship organizations already being able to bid? Was it?
I'm looking.
Okay, I feel like we received conversation about that. And I could be misremembering.
I don't have anything.
Okay. Let me.
Meaning if we could have more than one nonprofit.
Right, correct.
I believe that is the case. I think we did used to have two.
And I think that's what he confirmed by email,
Okay,
that we could
yeah.
have more than one.
Representative Selig?
Thank you. Well, I won't object to I don't believe I'll object to the interim study. I just will say that so many people spoke in opposition to the bill, including the one of the sponsors, the supplemental sponsors, because of the questions and everything else. It just feels like legislation that needed to have been researched before it came forward as legislation. And I don't know that it necessarily needs study so much as for the people working on it to understand what they're working on.
Any other discussion? Representative McDonald?
Thank you, Madam Chair. I actually share similar concerns because of the bill opens us up to nonprofit companies. And I know that's the model used in other states, but New Hampshire is not like other states. And I think we should be proud of the way we do implement the program. And so I'm curious what would end up studying here if we can agree now that maybe this is not the direction we should go into. So for that, just.
Representative Belcher?
Thank you. And I'll just add that I don't think this is the right way to do it right at this moment, but I don't mind the idea of studying, especially because just based on the fact that we do have a fiduciary duty to the people, to the taxpayers, to make sure we're getting the best bang for the buck. We can look at it. We can make recommendations later on it. Maybe there's a way to word this, maybe open it up. Maybe there's not, but I don't see a problem with studying it for now.
Representative McDonald?
Thank you, Madam Chair. And I by no means am trying to be argumentative. I understand we do have a fiduciary responsibility to the taxpayers, but a for-profit company has a fiduciary responsibility to its shareholders rather than to the students and their education. And I would hope we could take an affirmative stance today that we put students over for-profit companies.
Representative Murray?
Thanks, Madam Chair. I also just wanted to mention that I don't think this limits anybody into either for-profit or nonprofit status. We just happen to hear from another perspective that was a for-profit entity, but based on the conversation that we just referenced previously, it could be any individual who comes forward at another time.
Any other comments? Seeing none. Madam Clerk, the motion is interim study.
Vice Chairman Parental.
Yes.
Representative Terry.
Yes.
Representative Dry, yes. Representative Belcher.
Yes.
Representative Freeman.
Yes.
Representative McDonnell,
No.
Representative Tanzer,
Yes.
Representative Nato,
Yes.
Representative Cornell,
Yes.
Representative Murray,
Yes.
Representative Woodcock,
Yes.
Representative Hall,
Yes.
Representative Damon,
No.
Representative Selig,
No.
Representative Kluger,
Yes.
Representative Snodgrass,
No.
and Chairman Noble.
Yes.
9 yeas, 8 nays. 9 to 8.
Children's absent.
Okay, did I?
Yes, wasn't it? Yes.
I will write a minority report. I don't intend to unless someone disagrees to argue that on the floor, though.
That's fine. Thank you. No, we are in alignment with you on this one. Okay, and feel free to send me a message if you wish. I'll be happy to, use my English teacher powers to edit.
Yeah, I will be in communication with the other dissenting votes.
It's understandable. Sometimes votes don't go the way we expect them to go, and you never know.
We'll open the executive session on House Bill 1490, requiring scholarship organizations to provide written notice to parents explaining the parent's requirement to provide written notice upon termination of a home education program. And I look to Representative Parental for a motion.
Thank you, Madam Chair. I move an expedient to legislate on House Bill 1490.
Is there a second?
A second.
Representative Parental?
Yes, thank you very much. This exact language was included in House Bill 1268, which we passed earlier this morning out of committee. Therefore, I no longer see this bill in particular as necessary.
Ditto.
Okay. Any other comments? Representative Murray?
Question, Chairman
Oh.
Noble.
Yes.
Thank you. I thought when we took this bill, I was trying to get to it, but Representative Pertnell was already coming by. When we had this bill, I thought they said they already do that once. There's the scholarship organization, the EFA, we call it organization.
Yes.
So they already do that. And I understand the bill this morning that Representative Pertnell was commenting about, referenced that. But at the testimony, he said that they already do that already.
They do that, and
So I don't know why we're doing it twice.
they do that, and it's in their handbook. And it wasn't always clear to home educators that they were terminating their pathway. However, since we had the hearing, I've spoken with the scholarship fund, and they have made it even more clear for the upcoming 26 to 27 handbook. So I no longer think this is necessary.
I don't think that this exact piece is in 1260.
Oh, okay, sorry. I got confused with my other bill.
I think that, yep.
Either way, I think they've gotten this squared away, and they do not need to do. This
So why
bill is
would
no
it-
longer necessary.
Why would it be an ITL?
Because I don't need the
We
bill.
don't need it.
We don't need it.
It's not out to pass, it's ITL.
Okay. So this says, the ITL is your motion?
Mm-hmm.
Ah, stupid me, that's two in a row now. Oh, wait, Representative Dwyer script the count. I script, I understand.
Rubbing off on.
All the rest of you have a chance to
Forgot
talk
which
this
bill it
afternoon.
was.
Margaret and I are clear. We're done.
We'll see you later.
I apologize, Representative Pertnell, my error.
Any other?
No, my error. My cold medicine.
Everybody's on the cold minutes. Any other comments? Seeing none, Madam Clerk, the motion is ITL.
The motion is ITL. Vice Chairman Peternell.
That makes sense now.
Yes.
Representative Terry.
Yes.
Representative Dry, yes. Representative Belcher.
Yes.
Representative Freeman.
Yes.
Representative McDonald.
Yes.
Representative Tenzar.
Yes.
Representative Nato.
Yes.
Representative Cornell.
Yes.
Got it now this time. Thank you. Representative Murray.
Yes.
Representative Woodcock.
Stand corrected, yes.
Representative Hall.
Yes.
Representative Damon.
Yes.
Representative Selig.
Yes.
Representative Kluger.
Yes.
Representative Snodgrass.
I'll go yes again.
Representative Chairman Noble.
Yes.
17 yeas, 0 nays.
That's 13.
Can this one go on consent?
17. I didn't know we didn't hear us change it. It's 1490.
We'll open the executive session on House Bill 1513 relative to reporting and transparency reports for Education Freedom Account Program, and I look to Representative Belcher for a motion.
Yes, I move ITL.
Is there a second?
Second.
Representative Belcher, do you have comments?
Yes, thank you, Madam Chair. So this bill, it purports to bring a lot of what is currently the contract with the EFA provider into law. I don't view this as being, first of all, necessary because it's in contract. It doesn't really need to be in law. It also could be constraining on any future contracts for which the executive might need a little bit of wiggle room in order to get a contract done in the future. And finally, I would suggest that the last provision allowing for unlimited open-ended and unlimited inquiries, it could be a mechanism that could bog down the provider at some point in the future if people were so inclined as to continually submit more and more requests. Thank you.
Anything from the second?
Yes, thank you. In talking about EFAs with a number of people, I've always found it helpful to show them exactly what's identified in on the websites, and there's a lot of information there. I think I agree with Representative Belcher there that this is a contract part. They're doing their part. Things are accessible, and I support ITL.
Any other comments? Representative Selig.
Thank you, Madam Chair. I will not be supporting the ITL. I think that it is crucial that we increase transparency about the EFA program and the impact that it is having on our state, especially fiscally.
Any other comments? Representative Hall?
Thank you, Madam Chair. I just want to note that this bill was introduced by 7 Republicans from the House and the Senate. And what we heard was it was introduced for clarity and consistency. For that reason, I'm going to be voting no.
Okay. Any other? Representative Murray?
Madam Chair, and I also agree and concur with Representative Hall and Selig. My understanding is that the initial audit still hasn't fully been completed. I know that there's still things underway, and this would be another tool to ensure that we were continuing to make certain that we had all of the information available to us for that transparency. So I agree with my colleagues.
Representative Cornell?
Thank you, Madam Chair, and I will be voting ITL too. And one of the reasons why is because it clarifies when reports have to be provided, information within 45 business days. And we have another bill coming up later that gives pretty big penalties if reports aren't provided within a certain amount of time. So I think if we're going to be consistent with that, we should be consistent across the board and do that too. I meant not to pass, I'm sorry. I didn't mean to pass.
Any other comments? Seeing none, Madam Clerk, the motion is ITL.
Vice Chairman Parental.
Yes.
Representative Terry.
Yes.
Representative Dry, yes. Representative Belcher.
Yes.
Representative Freeman.
Yes.
Representative McDonald.
Yes.
Representative Tenzar.
Yes.
Representative Nato.
Yes.
Representative Cornell.
No.
Representative Murray.
No.
Representative Woodcock.
No.
Representative Hall.
No.
Representative Damon.
No.
Representative Selig.
Nope.
Representative Kluger.
No.
Representative Snodgrass.
No.
And Chairman Noble.
Yes.
9 yeas, 8 nays.
Representative Selig will be writing the report. We'll open the executive session on House Bill 1521, clarifying the definition of home education, and I look to Representative Peternell for a motion.
Thank you, Madam Chair. I move inexpedient to legislate on House Bill 1521.
Is there a second?
A second.
Comments from Representative Parental?
Yes, this language is included in House Bill 1268, which we passed earlier this morning. Therefore, I do not think it is necessary any longer.
And I agree.
Any other comments? Seeing none, Madam Clerk, the motion is ITL.
Vice Chairman Petronel.
Yes.
Representative Terry.
Yes.
Representative Dry, yes. Representative Belcher.
Yes.
Representative Freeman.
Yes.
Representative McDonald.
Yes.
Representative Tenzar.
Yes.
Representative Nato.
Yes.
Representative Cornell.
Yes.
Representative Murray.
Yes.
Representative Woodcock.
Yes.
Representative Hall.
Yes.
Representative Damon.
Yes.
Representative Selig.
Yes.
Representative Kluger.
Yes.
Representative Snodgrass.
Yes.
Chairman Noble.
Yes.
17 yeas, 0 nays.
Goes right into the minority report. Oh, I'm kidding, sorry.
We will open the executive session on House Bill 1529, repealing the Reading Recovery Training Program, and I recognize myself for a motion of OTP. Is there a second?
Second.
And I will recognize myself again. This is a training program that used to be administered by the department. It hasn't been in years. So I did check with them before I put this bill in, and they said it was okay to repeal. And that's it. Any comment from the second?
It seems like nothing's stopping them from getting together and trying to have a committee and study this a little more on their own, but I think it's fruitless for us to keep this going.
True. Thank you, Representative Nato. It doesn't stop the districts from continuing to use this program. It is just that the department doesn't administer this training program anymore. If the districts are using Reading Recovery, they can continue on. And any other questions? Representative Woodcock.
Thank you, Madam Chair. I have some reservations about allowing the department off the hook for Reading Recovery. Clearly, it's a Title I program. Clearly, it's for first grade youngsters. And I acknowledge that you talked the other day, Madam Chair, about DOE saying that they don't do it anymore. It doesn't negate the fact that the bill is talking about they should be doing that. They shall be providing the training. After reading, everything else comes next in my book. Math, science, all that comes first. We have to get the most important. These are the kids who are already the most suspect. So just to say the DOE, just because you haven't been doing it on the last commissioner, doesn't mean we should be doing it now. I think the schools, it was clear the schools that spoke to using that, it's only reading specialists, not every single teacher. It's people to train. Granted, the school systems could hire the trainer to come in and train. Why do we keep on passing more and more money from the state back down to the local schools, to siphon that back down local? I think there's nothing more important than reading when we start with youngsters, and to take away the responsibility for the provide the training to the school systems if they choose to use it. That's all. And so I think we're making an error allowing that. And granted, if you're already trained, you still have it, but the retrain. I just think that we're making an error. We're saying the wrong message. We're talking about scores. We're talking about reading and literacy. But we're saying the wrong message. Here's a handle for the state to give a hand to school systems. That's my opinion. Thank you.
So they aren't not providing training. They're just using a different program.
This was, yeah.
Sure.
The bill was Reading Recovery, and that's what some of the schools are still using.
Yep.
And the training is supposed to be provided by the department, even though some school districts are using other programs as well. This is still only a grade 1 program, basically a Title I program. So the school, DOE is not saying it's not valid. We have no data from DOE from saying it's not valid, it doesn't work anymore. But we're saying they don't want to do the training, they haven't been doing the training. Doesn't mean the school district shouldn't be eligible for that and have their faculty, staff, and teachers who have already been trained to be caught up to it. Schools pay the local money for the cost of the teacher being out and all those things. I just think we're allowing DOE off the option here to provide a program in the most critical part of student development academically, which is grade 1, those in need. Those of you who have been involved in education know you get a year behind, then it's a year and a half or 2, and then catch up with way beyond. So that's just my opinion. I think we're making a big error allowing them off. That doesn't mean they're going to do it, no. But at least we have the school systems have the right to say, you know what, it's right here in the law. It's right here in the law. You're supposed to give us a trainer. So there's some school districts just can't afford it. We keep shifting state, another cost of state down to local. Thank you.
Thank you. Representative Murray.
Thank you, Madam Chair. I think we heard in testimony that initially, those who are currently using the program, initially their training was done at the department level and it cost, somewhere around, $10,000 or as much as. However, their current recertification programs are touching up on skills are around $1,000. And I agree with Representative Woodcock when we were saying that we continually ask districts and local communities to pick up more and more and more of the tab. And when we're talking about tier 2 or 3 reading intervention, I agree, because once students leave first grade, enter into second and third grade, the expectation for vocabulary continues to increase. So why we would be taking away a tool in the toolbox at the department level to have it a valid sort of tool for them to apply for. It even says in the statute that if there are no funds available, the department can just state that. So then it would say to them that, yes, we understand that you have a desire to use the program, but you're going to have to find funds on your own. And it does further enumerate that down below. So I can't support removing it either.
Any other comments? Representative Freeman?
A question, Madam Chair, and thank you. Do you know how many reading recovery training programs we have at the state level? Is this the only reading recovery training program?
I believe they are now training in the using the letters program.
Thank you.
Any other comments? Representative Murray?
Thank you, Madam Chair. I do just want to note, though, when we heard in testimony, in addition to the letters program, which I agree with you, that's what they're using, they also said, with response to intervention, there are a myriad of different things that students, identify and connect with as far as being able to improve their literacy. So there are teachers who have a broad spectrum of experience through, whether it's through foundations or reading recovery program or letters or Dibble, whatever it is, those tools are used. And so I don't understand why we would remove an option like this at the department level. I think we even heard that some people were writing grants to be able to get grant funding to offset some of the costs. And they were concerned that that wouldn't be available to them potentially as well through Title I.
Okay. Any other comments? Seeing none, Madam Clerk, the motion is OTP.
Vice Chairman Parental.
Yes.
Representative Terry.
Yes.
Representative Dry, yes. Representative Belcher.
Yes.
Representative Freeman.
Yes.
Representative McDonald.
Yes.
Representative Tenzar.
Yes.
Representative Nato.
Yes.
Representative Cornell.
No.
Representative Murray.
No.
Representative Woodcock.
No.
Representative Hall.
No.
Representative Damon.
No.
Representative Selig.
No.
Representative Kluger.
No.
Representative Snodgrass.
No.
And Chairman Noble.
Yes.
9 yeas, 8 nays.
Oh, Steve, no.
Who's going to do it?
Woodcock.
Sorry.
My favorite bill of the day.
Mine too, actually. It's the easiest for sure. We will open the executive session on House Bill 1712 relative to charter conversion schools. And I will recognize myself for a motion of ITL. Is there a second?
I'll second that, Madam Chair.
Okay, my only discussion is I haven't worked on this bill at all. I haven't looked at it probably since I put it in September. And so I should have withdrawn it. Too many other things going on to even think about that, but so I'm gonna move ITL. Any other comments?
Thank you, Madam Chair, for your honesty.
Yep, she did second. Yep. Any other comments? Seeing none, Madam Clerk, the motion is ITL.
Vice Chairman Peternell.
Yes.
Representative Terry.
Yes.
Representative Dry, yes. Representative Belcher.
Yes.
Representative Freeman.
Yes.
Representative McDonald.
Yes.
Representative Tenzar.
Yes.
Representative Nato.
Yes.
Representative Cornell.
Yes.
Representative Murray.
Yes.
Representative Woodcock.
No.
Representative Hall.
Yes.
Representative Damon.
Yes.
Representative Selig.
Yes.
Representative Kluger.
Yes.
Representative Snodgrass.
Yes.
And Chairman Noble.
Yes.
16 yeas, 1 nay.
Representative Woodcock should write the minority report.
Yes, thank you.
Consent. Yep. Yep. We will open the executive session on House Bill 1774 FN relative to qualifying scholarship granting organizations and programs of low earning outcomes. And I look to Representative Parental for a motion.
Thank you, Madam Chair. I move ought to pass on House Bill 1774.
Is there a second?
Second.
Discussion from Representative Parental.
Yes, I would like to put forth Amendment 2026-0915H.
Is there a second?
Yes.
Don't have the amendment for some reason. Okay.
Is that it?
Discussion, Representative Parental on
Yes.
the amendment.
Thank you very much, Madam Chair. This bill, I'm going to speak to the bill and as well as what is removed in the amendment.
Okay.
This bill puts into statute the state opting into the federal tax credit scholarship and federal tax credit for contributions to scholarship granting organizations. It also approves workforce training programs in consultation with federal workforce Pell Grants. one of the benefits of this program is that students can use the scholarship grants for after school augmentation of their education. But what we removed in the amendment is the institution of higher education, the low earning outcome programs. So anything related to the low earning outcome programs has been eliminated in the amendment. So we're only specifically addressing the scholarship organizations.
Anything from the second? Any other discussion? Representative Woodcock.
Question, why are you removing that?
We were worried that it would negatively affect certain degree programs, particularly from the community colleges.
Thank you.
Representative Selick.
Thank you very much. I acknowledge I missed the hearing on this bill and I'm still working on catching up on watching all of those on YouTube. It's a few hours behind still. But 3 a.m. That's great. So I just want to understand the goal of this bill is to say that people can donate to this program and get tax credit rather than to take away ability for people to access Pell Grants. I got confused in all the language of the bill. And so in 3 readings, I still didn't figure it out. So I just want to make sure I understand what we're actually doing.
No, they can actually access Pell Grants for workforce programs.
And people can make donations atop.
Yes.
Okay.
It's kind of confusing because we're approving a federal program as part of the state. So, and the governor has already opted into this program, but they would have to opt in. It needs to be renewed annually. So by putting it in statute, the governor would no longer have to do that. It would just be in statute.
Any other comments? Sorry, Representative Murray.
Yes, thank you, Madam Chair. I was also just wanting to make sure that I understood that Pell Grants are income sensitive programs. So would this be true for the Workforce Innovation Board approving training programs as well? Because the Pell Grant at the higher ed institution levels are income restricted to ensure. Okay.
I believe so. Yeah.
Okay, any other comments?
Open to caucus.
Okay.
Real quick.
Yep.
Madam Chair, my experience, at least when I was on the Criminal Justice Committee, was that as long as you were seated before the vote was called, you were accepted to vote. But I leave that to your discretion.
Why would it just be like the House? They make a motion on the floor, they stop and call it back in from the outside in the ante room. Same rules.
A little bit. Okay, we are back from caucus. Is there any other comments on the amendment? No, oh. No comment?
No.
Okay. Madam Clerk, the motion is OTP on the amendment.
Vice Chairman Parental.
Yes.
Representative Terry.
Yes.
Representative Dry, yes. Representative Belcher.
Yes.
Representative Freeman.
Yes.
Representative Litchfield.
Yes.
Representative McDonald.
Yes.
Representative Tenzar.
Yes.
Representative Nato.
Yes.
Representative Cornell.
Yes.
Representative Murray.
Yes.
Representative Woodcock.
Yes.
Representative Hall.
Yes.
Representative Damon.
Yes.
Representative Selig.
Yes.
Representative Kluger.
Yes.
Representative Snodgrass.
Yes.
Representative Noble.
Yes.
18 yeas, 0 nays.
Representative Petronel, do you have another motion?
I move ought to pass as amended on House Bill 1774 with Amendment 20260915H.
Is there a second?
Second.
Any more discussion on the bill?
No, I think we covered everything.
Representative, anything from the second?
Nope. We're good to go.
Okay, Representative Selig.
Thank you. I just want to say the bill raised some different questions for me, so I won't be supporting it as amended, but I believe I'm the only one.
Any other comments? Seeing none, Madam Clerk, the motion is OTPA.
Vice Chairman Petronel.
Yes.
Representative Terry.
Yes.
Representative Dry, yes. Representative Belcher.
Yes.
Representative Freeman.
Yes.
Representative Litchfield.
Yes.
Representative McDonald.
Yes.
Representative Tenzar.
Yes.
Representative Nato.
Yes.
Representative Cornell.
Yes.
Representative Murray.
Yes.
Representative Woodcock.
Yes.
Representative Hall.
Yes.
Representative Damon.
Yes.
Representative Selig.
No.
Representative Kluger.
Yes.
Representative Snodgrass.
Yes.
And Chairman Noble.
Yes.
17 yeas, 1 nay.
No objection.
We'll open the executive session on House Bill 1644, permitting towns to unilaterally withdraw from a cooperative school district, and I recognize Representative Litchfield for a motion.
Interim study, please.
Is there a second?
I'll second that.
Any discussion from Representative Litchfield?
Yes, Madam Speaker, I move that HB 1644 be referred to interim study. The committee is advancing House Bill 1374, which refines the existing withdrawal process. HB 1644 goes further, and the committee believes those broader changes deserve careful legal and fiscal review before permanent statutory changes are made.
I appreciate the promotion, but I don't think I'm quite ready for that yet.
Oh my gosh,
Anything from the
I
second?
did it late last night.
No, thank you.
Any other discussion? Representative Selig?
Thank you. I personally believe the bill should be ITL, just as I believed that the very similar bill we voted on earlier should have been ITL'd.
Any other comments? Seeing none, Madam Clerk? Motion is interim study.
Vice Chairman Petronel.
Yes.
Representative Terry.
Yes.
Representative Dry, yes. Representative Belcher.
Yes.
Representative Freeman.
Yes.
Representative Litchfield.
Yes.
Representative McDonald.
Yes.
Representative Tenzar.
Yes.
Representative Nato.
Yes.
Representative Cornell.
Yes.
Representative Murray.
Yes.
Representative Woodcock.
No.
Representative Hall.
Yes.
Representative Damon.
Yes.
Representative Selig.
No.
Representative Kluger.
Yes.
Representative Snodgrass.
No.
And Chairman Noble.
Yes.
15 yeas and 3 nays.
Can that be on consent? Okay. Did we want it on consent? Okay.
Consent? Okay.
We will open the executive session on House Bill 1669, establishing a teacher's bill of rights. And I recognize Representative Litchfield for a motion.
I would like to move the committee recommend interim study.
Is there a second?
Second.
Discussion from Representative Litchfield.
Yes, thank you, Madam Chair. The partnership between teachers and parents is essential to student success. While we recognize the importance of this topic and respect the intent of the bill, the committee believes additional time is needed to ensure the language is clear, balanced, and thoughtfully aligned with existing law.
Anything from the second?
Yes, thank you, Madam Chair. I would only add that I think there might be a path forward to do this really well. The difficulty is going to become translating the negative constitutional rights into their practical application in the teaching environment, perhaps in the form of resolution or something, but I think we can study it to maybe get that right.
Any other discussion? Representative Selig.
Thank you. I appreciate that the prime sponsor wanted to do more to support teachers. I don't think this is the vehicle for doing so. And again, I think the bill should be voted inexpedient to legislate, so I'll be voting in opposition.
Any other discussion? Seeing none, Madam Clerk, the motion is interim study.
Vice Chairman Parental.
Yes.
Representative Terry.
Yes.
Representative Dry, yes. Representative Belcher.
Yes.
Representative Freeman.
Yes.
Representative Litchfield.
Yes.
Representative McDonald.
Yes.
Representative Tenzar.
Yes.
Representative Nato.
Yes.
Representative Cornell.
Yes.
Representative Murray.
Yes.
Representative Woodcock.
Yes.
Representative Hall.
Yes.
Representative Damon.
Yes.
Representative Selig.
No.
Representative Kluger.
Yes.
Representative Snodgrass.
Yes.
And Chairman Noble.
Yes.
17 yeas, 1 nay.
Consent? Yep. We'll open the executive session on House Bill 1804. Consolidating school administrative units, making chief school administrator jobs an elected position, and defining education roles. And I look to Representative Belcher for a motion.
Thank you, Madam Chair. I move interim study.
Is there a second?
Second.
Discussion from Representative Belcher.
Yes, thank you, Madam Chair. So this bill, it would seek to significantly consolidate SAUs seeking savings in the economy of scale. It also makes numerous other electoral, positional, and policy changes within it. I think we reasonably could anticipate some savings from SAU consolidation. However, there are also a lot of other details within the bill that I think need a little bit more work, a little bit more understanding. Who's going to be responsible for various things under this new paradigm, the manner of elections, and all of the rest of the smaller details that are really going to be quite significant when implemented. So I think we need to look at this, study it, maybe come up with a recommendation.
Anything from the second?
No, other than to affirm what my colleague has already said and to remind us all that we heard substantial and significant questions raised in testimony when this bill was presented. It's not quite ready yet, to put it mildly.
Any other comments? Representative Selig?
Thank you. I believe this bill should be an expedient to legislate, and having worked in a state where we had countywide school districts and rather large, what are referred to here as SAUs, I can tell you consolidating doesn't necessarily mean cost savings. It just means spreading people out along a much wider area. Because we were countywide school systems and we had, at the time, 16 high schools and then the various middle schools and elementary schools that fed up to it. We needed assistant superintendents for subject area content, assistant superintendents for different grade levels. All of them needed support staff, and all of that ended up probably costing just as much, if not more, than the current model we have in New Hampshire. So I don't think this is a good idea. I also think the idea of electing someone to be a superintendent every other year is an incredible expenditure, because they're going to have to spend so much time working on campaigning. They won't actually be able to do their job of being a superintendent of schools, which takes a tremendous amount of work. Generally, from the superintendents I speak to, is often an 80-hour-a-week job. And it's a year-round job. It's not something you can take time off for going out door knocking across an entire county. So I personally will not support interim study because I don't support any component of this.
Representative Murray?
Thank you, Madam Chair. I think we heard a lot, like Representative Terry said, there was a lot of information that came forward, and I do believe that this is nowhere near ready, not the least of which we haven't fully funded public education as it currently stands. And so moving into a process where we would consider commingling things or consolidating them at the county level. We heard from the Association of Counties. We also heard from the Cheshire County Administrator on a myriad of legal questions and implications that could happen as a result of this. And it did seem to me that there were a number of questions about downshifting cost just to a different level of governance other than the state's obligation to fully and adequately fund public education. So I also will not support an interim study on this.
Representative Hall?
Thank you, Madam Chair. I also will not support it. I support studies, commissions, when they make sense. This one doesn't make any sense. Like, you're going to elect superintendents. I worked in the school for 40 years, worked closely with superintendents. It truly makes no sense. You're going to have one superintendent per county. You're going to elect these people, and they're going to spend their time campaigning. So studying something that makes zero sense is not sensible. Thank you.
Representative Woodcock?
Thank you, Madam Chair. When the prime sponsor presented this, he continued to use the analogy, bigger is better. Bigger is better, we can handle those things. I'm not sure bigger is better in this case. As I said then, I said now, that the problems can be solved closer to where they begin. They would call it building principals, building superintendents, and local district. Clearly not some way down the other end of the county. So that's the other thing. I did go to college at one point, actually, and in that system, I was in a county, a state that used county government, but their county government was much more fluid than ours. Their county government, everything was already set. The whole county revolved around, the whole state around county government, much more fluid. We aren't even close to that. I mean, and then finally, until the prime sponsor can let me know who's going to call no school for snow, I don't think we can do that.
Any other comments? Representative Damon?
Thank you. I also will not be supporting interim study because I think it should be ITL. I was the ranking minority member on the SAU Consolidation Study Committee last fall, it is the opinion of the minority that the committee did not thoroughly vet this option, which is where this bill came from. We did not confirm economies of scale. We only casually looked at 2 other states that have some model of consolidation. We didn't study our neighbors thoroughly that we could learn a lot from where it's been happening or trying to happen in Vermont with great difficulty. This model is very significant downshifting of costs and responsibilities to both county and local and within school districts from superintendents to principals and other administrators who are not necessarily cross-trained. It's just not thoroughly vetted at all, and it simply doesn't fit New Hampshire.
Any other comments? Seeing none, Madam Clerk, the motion is interim study.
Vice Chairman Parental.
Yes.
Representative Terry.
Yes.
Representative Dry, yes. Representative Belcher.
Yes.
Representative Freeman.
Yes.
Representative Litchfield.
Yes.
Representative McDonald.
Yes.
Representative Tenzar.
Yes.
Representative Nato.
Yes.
Representative Cornell.
No.
Representative Murray.
No.
Representative Woodcock.
No.
Representative Hall.
No.
Representative Damon.
No.
Representative Selig.
Nope.
Representative Kluger.
No.
Representative Snodgrass.
No.
Chairman Noble.
Yes.
10 yeas and 8 nays. All.
Just for clarification, this one is obviously not going on consent, correct?
Correct.
Okay. Just, there's a fiscal note, although it says indeterminable, I can't imagine that it would be a small number.
It'd be a big number. The last one? 10-8. Yeah.
I feel like we have 3 more left, 2 more left. 3 more, yeah. 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 3 more left. Oh, on all? Don't you dare. Yeah.
We will open the executive session on House Bill 1817 FN, permitting all students the choice to attend the school district in which they reside. And I look to Representative McDonald for a motion.
Thank you, Madam Chair. I move ought to pass.
Is there a second?
Second.
Representative McDonald?
Yes, I have a further motion. I would like to move Amendment 2026-0911H, which I passed out this morning, but I have extra copies if anyone needs them.
Is there a second?
Second.
Discussion of the amendment, Representative McDonald.
Thank you. This discussion was alluded to this morning in the discussion on House Bill 1268. And the entirety of this bill as amended is word for word within 1268 in the first section. The reason for the duplication here is, in a perfect world, this bill wouldn't be needed as it is already in legislation we voted on earlier, but just in case something were to happen as that bill, the Home Education Freedom Act includes a lot of components, so if something else would be held up in the Senate or for whatever reason, this just allows us to separate this. As noted earlier, it's a little bit different as it relates to EFA program and not just home educated students. Walking through this amendment, you can see I did change the title of the bill as I just feel like the title is more fitting, but that has no impact on the law. And then line 10, it adds education freedom account, simply because there are 4 methods for compulsory education. The other 3 are listed. It makes sense to me for all 4 to be listed. I do understand that's a policy decision, so I can understand there's disagreement on that. A reason for that change was noted earlier in the technical advisory handed out by the Department of Education, saying that the way RSA 193:1-C is already written in current law, it allows free and important protections to home educated, charter, and non-public school pupils, but they don't apply to EFA students. So this is simply to say that I think it should. Moving on to line 12, again, this language is included in House Bill 1268, which we did pass this morning. It allows these students specifically to access the statewide assessment and the PSAT. And to be clear, the statewide assessment for 11th grade is the SAT. So although it's not explicitly stated, this would include the SAT as well. And then the final important change would be the last line of the amendment, line 25. It updates the statutory reference because admittedly in the original bill, I had the statutory reference incorrect. So that's my mistake. And so this amendment hopes to correct that mistake. This bill is the only bill I filed this year, and it's important to me. And I recognize that I did not do perhaps the best with the presentation, and the bill as written did not achieve the aims I had hoped. So I humbly ask your support of the amendment to really get to that aim and to address what the department noted in technical advisory. So thank you.
Anything from the second?
No, I think Representative McDonald covered that pretty well.
Any other discussion on the amendment? Representative Hall?
Thank you. Thank you, Madam Chair. I have a question in terms of this language was put in 1268. 1268, the purpose of that was to, was really about home education. This is not about home education, it's about EFA. So I'm just curious why it wouldn't have just been left, other than what you just said, to make sure it passes one place or another. I really never heard that strategy so much that you put it everywhere. But it didn't even seem to fit in the other bill. But yet now that it's already passed, it makes no sense that we have this. Well, first of all, it didn't belong in the first one, in my opinion. But I'll be voting against it for sure.
Okay, and to address that question, I understand what you're saying. The reason for it being included in the first bill, and I don't intend to speak for the sponsors of that bill, I'm not one of them, but it was simply because when filing the Home Education Freedom Act, we realized we had a shared interest in this area of law, as it is similarly related, again, not particularly just to home educated students as it impacts EFA program. And so I really commend the work of the sponsors and the people who worked on that bill to include this. And as for it being in 2 places, that's not necessarily an uncommon practice, as it has happened before. It simply delineates that the stated objection to this morning's bill was that this is a different section, as you noted, right? So I think it makes sense to separate it out. We did have 2 other bills today that we voted pretty bipartisan to ITL or to study simply because they were included in the home education bill. But this, as you noted, is kind of separate. It's not just home education. So I think it makes sense to have a separate discussion. If the Senate wants to keep these two ideas separate, perhaps they don't like this idea, they don't pass this bill and they take it out of the other one. That's up to them too. It just simply says that as a policy stance, this is important to us, that so important we want to do it twice.
I sure hope that's what the Senate does. Thank you.
Okay. There already was a reference in the amendment that we had a hearing on to 193:1-C, and that was Roman 2. So that was in there. Another reason I brought it into 1268 is because there was a change to include the statewide assessment and preliminary and the PSAT for a home education group that asked me to include that. Representative Belcher?
Thank you, Madam Chair. I just want to chime in. I'll be very happy to support this, even if this doesn't eventually wind up being the exact language, fine, whatever the concept. I think it really is a must pass for me, because the thing I hear the most about from parents who do use EFAs, the only dissatisfaction I'm hearing is that so often they can't get their children into their local, particularly into their local athletics in their schools, because the schools are looking to charge them an amount of money that is equal to or greater than the entire EFA distribution. So I think this is a necessary corrective to solve that problem for them.
Representative Murray?
Thank you, Madam Chair. And I don't mean to be funny. I'm being sincere when I ask this. I just want to make sure that we are not, the initial title of this bill in particular is permitting students the choice to enter into a district in which they reside. I just want to be clear that it could be that a student has a different wish than their parent or their legal guardian. And so I just want to make sure that that doesn't conflate with anything, that if the student has a preferred method and the parent has a preferred method, what then?
May I respond to that, Madam Chair?
Representative McDonald?
Thank you. And I actually shared your concern. As you know, OLS comes up with titles. I don't know the whim or rationale as to why. Since the bill was filed, I never really liked the title personally, which is why I changed it. So I hope you pass the amendment for that reason. So sounds like you're in support of the amendment. Thanks.
Representative Hall?
Thank you, Madam Chair. I think we mentioned sports. I think even more important than sports would be like CTE programs. They are very, very costly. So someone gets an EFA, now they can go take a $10,000 CTE program. That's like, again, that's crazy, in my opinion. Thank you.
Representative Cornell?
I know that the explanation that's been given is that this is the taxpayers' money and they pay for schools. But when you get an EFA put into your wallet, which is equal to probably the amount that the taxpayer has paid in their property taxes for the schools, and then to get to go take advantage of the public school, which they're not paying for now because they did get their money into their wallet. They're no longer paying for the public school. And to go take a free class, especially at a CTE program, is in my opinion, double dipping and getting twice what the other taxpayers are getting for their money.
Representative Parental?
Thank you, Madam Chair. I just want to point out again that public chartered school students receive the adequacy aid plus additional aid from the state.
Representative Belcher?
I just wanted to point out, because there is a bit of a symmetry there, that parents are being double dipped by, actually more than double dipped. They're being dipped by the locality, they're being dipped by the state, they're being dipped by the federal government, they're being dipped every which way for taxation, and only the state portion of the taxation would be flowing to the EFA grant. The local portion would not be.
Representative Woodcock?
Thank you, Madam Chair. And first, I do want to agree with Representative McDonald. OLS is very creative in some of the titles. You're correct. I'm not going to go back and beat the horse I did this morning. It was the same horse. But I want to follow up on what Representative Cornell and Representative Hall both spoke about, the EFAs and the CTEs. Beyond the money, which I think is you won't believe this, but I'm really not a big fan of EFA, either vouchers. But beyond that, the CTE program often has very limited spots. And these youngsters, or these parents of these youngsters, have selected to send this child somewhere else, which is their choice. That's the choice, that's the law. But they should not, in my mind, come back and take a spot of a public school student in a public school, particularly in a CTE program. I don't think you should come back to a public school to start with. But I do believe, because they've already opted out of that, but I do believe that this is really, we're gonna, the negative impact of losing that youngster's spot is significant to the public school youngster and parent who stayed in public school and want to go to a public school program in a CTE and can't get there, into there because of the numbers, because it's taken by someone from an EFA who never chose to come to public school.
Do you
Thank you.
share that same concern with the non-public school student? Because that is,
The non-public school student is in the law right now.
yes.
So I can't do anything about that. I'm talking about the bill that's on the table when you're creating an additional opportunity there, Chairman.
Representative Murray.
Thank you, Madam Chair. The other question I did have is I'm curious to know if you can refresh my memory as to why you moved towards including the PSAT, because the SAT is the test that the state does use for measuring. Is that, you said about home educators asking you for that?
They did. Apparently they have had an issue accessing the PSAT. Sure.
In accessing the PSAT, however, though, that is not necessarily a metric that we at the state use to, am I correct? For the SAT is what we're using in grade 11, I think.
I think so.
Madam Chair, may I respond to that?
Sure.
Thank you. Another reason the PSAT is valuable, it's taken in 10th grade. It's the only test that qualifies students to be a National Merit Scholar through the College Board. So if they want to go to college, I know we had some discussion on one of the homeschool bills that they make sure they get a diploma, or this is just another way that they can get into college, which is why I found it valuable.
Representative Selig.
Thank you so much for taking my question about this, or my comment. So I find myself unable to support this. I think had there been a component where the state would reimburse the towns, because if you end up with 5 extra students signing up to take geometry, for example, and your class is already at 23, that would take you over the state classroom size, which means you then have to offer another section, which means finding someone else to teach a course, which means paying someone else, which is an added burden on the town. And so because there's no portion of this that compensates the town for adding students back in who've already made clear that they want to be opted out, I can't support that. It's kind of like me going to the grocery store and saying, I want a big bag of grapes, but I'm not going to pay for them, but I'm going to take them anyway. And also, you're going to give me extra grapes because I asked for my grapes. And, you know, grocery stores don't do that because they're businesses. Schools are not businesses. Schools are a government entity designed to support the best interests of our entire community. And so I think unless we're going to find a way to actually support our public schools with public dollars, we shouldn't be using our public dollars for students choosing to not attend our schools and then expecting public schools to cover the cost of bringing them back in. There's not an equal and adequate education there, and it seems to me a violation. So I can't support this.
Representative Litchfield.
Thank you. So what I don't understand is I don't understand why we're segregating EFA students like this. They're only netting, granted, some might get more due to the free and reduced lunch or special ed, but they're netting probably $3,800. So I have a question regarding the CTE classes. I just want to make sure I understand. Is it typically like a one-off class, or it could be 2 or 3? Is it their entire program, or is it one? And the only reason why I ask, if I can finish the question and then you could educate me, but if the parents are paying whatever, there's $16,000 per year property tax or whatever, there's the cost per head per student. The EFA student is getting $3,700. The public school student, let's say the average cost per student is $21,000. It could be as high as $36,000. But in addition to that money being paid, are they getting that full-time programming plus a CTE class that could cost $8,000 to $10,000? Like, I just want to make sure I understand correctly. Does that make sense? I did.
Representative Selig will attempt to answer.
Okay.
So I'm not sure I can fully answer because your question.
If you're a high school student, you're attending
I
high school, you
understand
would you take a CTE in addition to your regular schooling?
Yes, so
So you'd cost per student plus, I'm sorry, it was not towards you, it was, I could hear over here, 8,000 to 10,000, right?
So the Oyster River school system does not have an in-house CTE program. So for our students who want to attend CTE, they go to one of 3 other CTE programs in the state. They go to Dover, they go to Somersworth, and they go to Exeter, depending on the specific program, because not all the programs are offered at all of the CTE schools. So for example, and in Dover, they have one in sort of pre-veterinary services and things where people can become technicians at vets' offices. So they can't become a veterinarian through the program, but they learn grooming and other kinds of pet care needs. That program is offered in Dover. It's not offered at most schools. So even students as far as Portsmouth come there. Those school districts all have to pay Dover the cost of having those students attend that program. And those courses are there's a limit to how many kids can get into them. So there's some kids who never can actually access them. Generally, you have to apply as a freshman to get into those CTE programs, and you can start them your sophomore year if you're able to. There are additional fees because there's additional transportation costs, there's additional teaching fees, and there's paying the tuition to the other district to cover the cost of those specialized programs, whether it's dog care or welding or hair care or culinary programs. So those are programs that are sort of both extra to and also part of your regular school curriculum. So you get your course credit through those, your high school credits. Those are in addition to your regular math class requirements, your regular social studies requirements, your civics education, your English, your years of foreign language, et cetera, towards your high school diploma. So each of them has a different amount of cost depending on what it is, right? And if you're enrolled in a public school system, the school district has budgeted for that when they have done their annual budget and said they can afford to pay for this many students to attend the CTE program, which is why it ends up being a lottery system to get in. It doesn't cover every student, and it's not open for everyone because the schools don't have the funding to put those programs in every school the way that we used to in the 1970s and 80s. So it's a different structure. Students from private school and parochial school who want to go to those programs have to pay extra to get into those programs, is my understanding. But either way, if we're going to present a bill that's going to say we're going to require schools to accept these students who've opted out of their schools, then we should be paying the schools for taking them back.
Representative Dry?
Thank you. So I went to the ED rules part, 13, let me get it right, 1304.02, which talks about CTE's sending and receiving boards enter into submit to the department an agreement signed by the chairs of each of the sending and receiving boards every 4 years. And part of that is the apportionment to the sending and receiving districts, including provisions for the apportionment of seats for chartered public school, non-public school, and homeschooled students residing in the sending districts. So there is a rule about this, about the apportionment, just adding that to the conversation.
I'm sorry, 1304, or did you say 30402?
1304.02.
Representative Hall?
Thank you, Madam Chair. I think the bottom line is sending the CTE centers charge tuition to the sending schools. That's really what it comes down to. It's not part of the per pupil cost. I believe it's a charge tuition to your public schools.
Representative Freeman?
Thank you, Madam Chair. Not all CTE programs are out of district. I know Manchester has a CTE program that's right in district. So that I do know. Not all CTE programs are out of district or out of that home-based school.
Follow up?
Oh, yeah, just, it's not a sending district if it's in your own district, that's all. Thank you.
Representative Woodcock?
Well, two things. I really hope this gets IPL, but beyond that, I think whoever's a homeschool person here, the point that Representative McDonald brought up about the PSATs should be followed up with either a floor amendment or something for the homeschoolers. I think that's a really critical piece and gives them a chance to assessment. Thank you.
Okay.
I think Muriel has.
Muriel? Oh, sorry.
Quick question on the
Representative
PSC.
Hall?
Oh, thank you, sorry. Thank you, Madam Chair. Just one question on the PSCT, is that they can't get access to it or they want it to get paid for?
I think what I was told was they were having trouble getting access to it.
But this one wants both, right? This says access and pay for it? Sorry, that was a follow-up.
If you're asking me, yes, that's my understanding.
I am asking you, yes, thank you.
Representative Murray?
Thank you, Madam Chair. And I just wanted to clarify, do we have an idea of the average cost of like a PSAT versus an SAT? Because I know SATs can, let me back up. I know that DOE, when we were in our training, talked about how if a student is satisfied with the score that they get in 11th grade, they can then use that for college entrance exams. I think that's wonderful. I am just curious to know how much a PSAT would be if we're absorbing the cost at the state level or if that's being absorbed at the local level, which I'm not sure which way that would go. If that would be a local cost or if that would be something at the state level that the PSAT would be absorbed.
I think it would be a state cost, actually.
I'm just asking.
Yeah.
I wasn't sure.
Yeah. Any other comments? Representative Selig?
Yes, thank you. Sorry. I know in my district that students take PSAT in 10th grade, but that's a practice version essentially. It doesn't count for National Merit Scholarship until 11th grade. If the students who choose to do that in the public school system have to choose to register to retake it in 11th grade to qualify for a National Merit Scholarship, and they take it in the fall, and the SAT is then administered in the spring. But that's a separate thing. Merit Scholarship, the Merit Scholarship version of that is done in 11th grade, not 10th grade. And anyone can actually go to the College Board website and register to take either. So, I mean, they have to pay for it, but they can register on the College Board website.
For the SAT, correct? Yes.
For both.
Okay. Representative Dry is showing me that the cost of the PSAT is $18 per student.
That's what I had.
Any other comments? Representative Damon? Oh. Okay. Any other comments? Seeing none, Madam Clerk, the motion is OTP on the amendment.
Vice Chairman Parental.
Yes.
Representative Terry.
Yes.
Representative Dry, yes. Representative Belcher.
Yes.
Representative Freeman.
Yes.
Representative Litchfield.
Yes.
Representative McDonald.
Yes.
Representative Tenzar.
Yes.
Representative Nato.
Yes.
Representative Cornell.
No.
Representative Murray.
No.
Representative Woodcock.
No.
Representative Hall.
No,
Representative Damon.
No.
Representative Selig.
Nope.
Representative Kluger.
No.
Representative Snodgrass.
No.
Chairman Noble.
Yes.
10 yeas, 8 nays. Wait, now we have to go to OTPA.
Already packing up my bill. Sorry about that. Representative McDonald, do you have another motion?
Yes, thank you. I move ought to pass as amended on House Bill 1817 FN as amended by 2026-0911H. Thank you.
Is there a second?
Second.
Any more discussion on 1817?
Simply that I appreciate your support of the amendment and I hope your support of the bill too. Thanks.
Any other discussion? Seeing none, Madam Clerk, now the motion is OTPA.
Vice Chairman Parental.
Yes.
Representative Terry.
Yes.
Representative Dry, yes. Representative Belcher.
Yes.
Representative Freeman.
Yes.
Representative Litchfield.
Yes.
Representative McDonald.
Yes.
Representative Tenzar.
Yes.
Representative Nato.
Yes.
Representative Cornell.
No.
Representative Murray.
No.
Representative Woodcock.
No.
Representative Hall.
No.
Representative Damon.
No.
Representative Selig.
No.
Representative Kluger.
No.
Representative Snodgrass.
No.
Chairman Noble.
Yes.
10 yeas and 8 nays. Somebody ready?
Who will write the minority report? Okay, Representative Hall.
Okay.
We will open the executive session on House Bill 1828 FN, requiring the Department of Education to establish an auditing process relative to teacher preparation programs at the post-secondary education level. And I recognize myself for a motion of OTP. Is there a second?
Second.
So this bill would direct the department to establish an auditing process for literacy programs for teacher prep to ensure that they are aligned to the science of reading, which includes phonics, phonemic awareness, fluency, comprehension, and vocabulary teacher development. We had, if you look at line 6A, we had talked about putting in the word applicable educators. So it's not all educators. It's only supposed to be those that will be teaching reading. I started messing around with that language a little bit, and it was, I think I might have been changing the meaning of it. So I think I'm going to probably bring a floor amendment for that so that I can run this by Mr. Appleby at the department. And that is all. Anything from the second?
Nothing further.
Any other comments? Representative Damon?
Thank you. Being the sub, this is my first read. Does this apply to private institutions?
I don't believe that it was meant to.
It doesn't specify public or private.
Okay. Another thing to fix. I love amendments. Any other comments, Representative Selig?
Thank you. I know from, we received a question from UNH about some of the language of this. They raised questions about the phrase, the science of reading, and whether or not it has legitimacy, and had some questions pertaining to that. I know I forwarded that email to the committee when I received it. I also, having been a supervisor of graduate students becoming teachers, just feel this is really cumbersome, the way this is written and designed, and I don't feel that I can support it as a matter of legislation.
Representative Woodcock?
Thank you, Madam Chair. During the testimony, we asked Ms. Appleby, and then follow up, it came out that some of the colleges in our school system, in the state system, don't teach these particular issues in the teacher preparation program. So I was trying to figure out if the colleges are not teaching that in the teacher preparation program, and the DRE is requiring that for licensure, how does that play out in Peoria?
Can you point me to the line where it says it requires it for licensure?
That was the point of the bill, wasn't it?
No,
To
it's
ensure
to
they had-
audit teacher prep programs for literacy to see if they align to the science of reading.
And yes, but, okay, but Mr. Appleby is the one that, Mr. Appleby is the one that said that some of the colleges are not teaching this. So I just didn't know if there's any more follow-up on how that was going to occur. That the the strategy for reading line was not being taught in the education programs at the colleges.
So once, oh, you mean after the audit is done, yeah, haven't got that part yet.
Okay, thank you.
Representative Murray?
Thank you, Madam Chair. I did have a question with regard to subsection A of the original bill. When we're looking at ensuring that all educators complete coursework in evidence-based strategies for effective literacy, is that assuming that somebody is just doing a Gen Ed K-12 licensure, or is this open to, like, for example, if your practicum and your teaching experience is only in elementary education, I could understand having that focus in, I think that's enumerated in subsection B. But when we're talking about people who are educating at a higher level, secondary or secondary education, are you stating that all of those same phonemic awareness, fluency comprehension, those are things that we want to ensure they're teaching at the secondary level as well? I'm just wanting to make sure I'm understanding that.
We can't ensure it because college not teaching it.
Representative Parental?
I think we already addressed that. I mean,
Right?
in the conversation about applicable educators, like we do want to differentiate exactly who needs this
It would be
level of education.
those who are teaching reading.
Yeah.
Subsection A does not say that.
I understand. I need to bring up
Yeah.
for amendment. And I would have had one for today, but as I was messing around with the language, it's very confusing.
Okay.
And so even if I change something, I could actually change the meaning or what it does. So I just was trying to be careful there and want to run it by Mr. Appleby first. Representative Selig.
Thank you. I understand the intent to bring a floor amendment, but we're being asked to vote on the bill that we have before us. And it's hard for me to vote about something where we don't actually know what it's going to say. And so while I appreciate that there's an intent to bring a floor amendment, I would hope that you would send us copies of it prior to it being on the floor so that we know before we get to the floor what you're intending us to vote on. But I can't in good conscience vote in favor of something that we know is currently unclear without actually seeing the language of what would clarify it. To me, that would be a disservice to my constituents.
No, I completely understand, and just so you know, we do talk prior to session. If there is a floor amendment, I have sent to the ranking member prior to voting, so I will do so again. Representative Damon?
Thank you. So if I'm understanding this correctly, please advise me if I'm not. This would create a statute that tells our higher education teacher training programs how and what they should teach, that we would be I'm going to choose to use the word imposing curriculum on them.
I mean, this is just auditing what they're doing now. We haven't got to a point where we're saying you have to go this way. We want to see what's going on out there today because there is an issue with reading in this state. So something isn't working. So we need to dig into the root cause of the problem. And this is part of seeing what's going on.
Wait a minute. Pull up.
Follow up.
So in line 6 through 9, or 4 through 9, it says that it's reviewing, as you just noted, to ensure that all educators complete coursework. You don't need me to read you the rest of those lines. Yeah. So we are then saying that that coursework has to be provided.
No, we are saying that they need to review to see if this is what they're actually doing or not.
May I continue?
Yeah.
So then in subsection B, lines 10 through 14, we are then saying that the college learners can only do their teaching training in classrooms with this format of reading curriculum.
I would say that that's actually part of the review. So and so does A. A also says ensure. That these are the things that they're going to be looking at.
I guess it's a difference of interpretation. And to that end, my final part would be, this bill just doesn't seem, whether you agree or disagree with the premise of it, it doesn't seem at all clear or ready to be voted on.
Representative Hall?
Thank you, Madam Chair. I just am curious, on the DOE right now, they audit these schools, right? They audit the programs, I mean, the teacher prep programs. That's a yes or no. I don't know, I'm asking the question. Do they right now have an auditing process for just looking over the teacher prep program?
I do not know.
Okay, so follow up. Let's say they do. This wouldn't really, I'm just wondering why this has to be in statute. If the DOE audits these and knows what's going on, why do we have to put it in statute that they're going to establish a process if they already do it? But we don't know if they already do it. Is that what you're saying?
Correct.
Okay, so I think that would be a good question, follow up, sorry.
Mm-hmm.
I think that would be a good thing to know before going forward on this. Do they already do it? Thank you.
That is what the bill is for.
But if they already do it, I mean, it's asking if they already
I think we would have heard from the department if they already do it. They were here during the hearing.
Yeah, can I follow?
Sure.
Yeah, so I was here for that hearing, but this is specific to, well, actually, it's not specific to literacy right now. It's specific to anything. But at the time, when he testified, he was talking about the literacy program. So I guess it doesn't even match up to what we're really talking about. And I know you want to do a floor amendment, but
I do want to do a floor amendment, but this is preparation program literacy audit. Representative Belcher.
Thank you, Madam Chair. I was just going to point out that it did not appear in the testimony that this program was being audited in this manner. I wouldn't expect teachers' colleges to simply cooperate with the department in such an endeavor unless that was in statute. And just to clear it up, they're certainly using the word ensure, which it uses twice, it appears, implies rather strongly that they ought to be doing this. But when it looks like, okay, when you go down lower, it says, well, what are we doing about it? Well, if they're not doing it, they're going to post it on their website. It'll be part of the report.
Right.
Can you say that again? I missed what you said at the very end.
Sure. So if they're not aligning it, or if they are for that matter, what do we do about it? Well, it doesn't cancel their certification or anything. It puts it on their website so we can see it. No, it doesn't threaten their accreditation or anything. It puts the report on the website so we can see.
Thank you.
Representative Murray.
Thank you, Madam Chair. I have one other question regarding section 3. When it says the department, shouldn't that be the State Board of Education shall adopt rules, not the department?
Oh, yeah.
I'm sorry. I could be wrong. It was my understanding that the State Board of Ed is the one who adopts rules under, not the department.
Yes, I think you might be
Sorry.
right about that. Any other comments? Representative Freeman?
Thank you, Madam Chair, and I've listened to everyone's concerns about this bill, and you've been very transparent about this not being what you would like, and you will introduce a floor amendment. Madam Chair, I'd like you to know that I have full confidence in you that whatever amendment you bring forward will remedy some of the concerns people may have. And so I would strongly suggest that if you have concerns about this bill, it might be a good idea to email the chair and allow her to take the opportunity to correct those problems. But I'll be supporting this bill in spite of the fact that it does need some narrowing and some language corrections. Again, Madam Chair, I have full confidence in your abilities.
Thank you very much. Any other comments, Representative Woodcock?
Nothing about your ability, Madam Chair. But I do, going back to Mr. Appleby's comments, he was talking about the reading specialist position. And he was talking about reading, writing teachers, either 1-6 or K-6 as where this became applicable. And I understand what you're trying to do there, Mr. Madam Chair. But I go back to Representative McDonald's comment about the title. In her phrase, and if you look at the title of this one, this is still going back to what Mr. Appleby said then. We're looking at post-secondary education levels, and some of the colleges in New Hampshire do not teach this in the post-secondary education levels. So that becomes a problem.
It's a teacher preparation program.
Correct. They don't teach that. That's the problem you brought up. That some of the, you're asking them to exam if they have it. He's telling you, no, they don't have it, and this is who to apply to. So you're really auditing, according to your title, you're auditing post-secondary education.
Correct.
So you're not auditing any public school.
No, we're auditing the teacher preparation programs for, like, teacher college,
At
teacher
teacher
prep
colleges.
programs. Yeah.
You have the responsibility.
Any other comments?
Yeah, a little on.
Any other comments? Seeing none, Madam Clerk, the motion is OTP.
Vice Chairman Parental. Yes. Representative Terry.
Yes.
Representative Dry, yes. Representative Belcher.
Yes.
Representative Freeman.
Yes.
Representative Litchfield.
Yes.
Representative McDonald.
Yes.
Representative Tenzar.
Yes.
Representative Nato.
Yes.
Representative Cornell.
No, until I see what's in the floor amendment.
Representative Murray.
No, thank you.
Representative Woodcock.
No.
Representative Hall.
No.
Representative Damon.
No.
Representative Selig.
Nope.
Representative Kluger.
No.
Representative Snodgrass.
No.
Chairman Noble.
Yes.
10 yeas, 8 nays. Who's gonna?
Representative Selig?
Madam Chair, just before we get to our last bill, do we have any sense of how many bills are coming from the Senate?
The last I looked, a couple of days ago, we had 10 as of right now. I don't know if there's any more coming. I'm not going to schedule any hearings for next week.
Thank you. I appreciate that.
I definitely could use a break. And plus we may have the 2 session days and that would just be a lot.
I said to meet the acting deadline date, that's fine, right?
Yeah, right. Okay. All set? Just while we're talking about schedule, I'll just point out a couple of dates to you. And I haven't gone through to see what we have for early bills, but the 2 dates that we'll be paying attention to is April 16th. That's for the early bills. And then May 7th is the rest of them.
Those are Thursday.
Yep. That's our deadlines, yep, for Senate bills. So I think we can take a week off. Okay.
Yes.
We'll open the executive session on House Bill 1836 FN relative to the input-based accountability system requirements and enforcement. And I look to Representative Parental for a motion.
Thank you, Madam Chair. I move ought to pass on House Bill 1836.
Is there a second?
I'll second.
Discussion from Representative Parental.
Yes, I would like to put forth Amendment 2026-0648H.
Is there a second?
I'll second.
Discussion from Representative Parental.
Yes, thank you, Madam Chair. I'll speak to both the underlying bill and the amendment.
Okay.
This bill was introduced simply to put a little carrot in front of the school district so that they would return their input-based school accountability system reports every even numbered year. And I know that when we were at the department for our training in January, there was a conversation about carrots and sticks. And this bill was requiring that the commissioner withhold grants from a public school or district until such time as the input-based school accountability system report is submitted. The question on the underlying bill was exactly which grants, and I used 198.4F, penalty for failure to report, to amend the bill so that all state aid would be withheld until such time as the IBAS report is submitted to the department. And that was the change in the amendment.
Anything from the second?
Thank you, Madam Chair. I totally support this bill as somebody who seconded, but this is long overdue. I think a lot of the problems that our districts are facing right now can stem from not being held accountable for not filing reports. So at this time, I strongly encourage all of us to support this in order to right what's going on in our districts and make sure that everyone's being held accountable.
Any other discussion? Representative Woodcock.
Thank you. Just Representative Parental, the state aid that's being withheld. I thought there was conversation at the last meeting that would be illegal because of the grant. I thought that the DOE had said to us that you can't do that because that was a grant. I think Nate Green was here. You can't withhold state aid. I know Representative Ladders talked about the implications he had on the emergency aid before for school building. They put that on the security aid form because they wanted to apply. But they weren't holding anything. They weren't going to put them in until they it couldn't apply to the program. So that was the first question. The second one, I'm reminded about what Jerry Fu said from the School Association, Superintendent Association. We're taking the most poorest communities and making it more difficult for them. We should be thinking more of supporting them instead of punishing them with this withholding aid. I don't know if you have any reference to that and clarify is legal versus illegal, but the withholding of the state aid.
Well, this is a requirement from the state for them, for the districts to demonstrate that they actually provide the opportunity for adequate education. So that we need this information from the districts in order to send their funding to them.
And I'm not suggesting, Representative Parental, that they don't need the information. But what I'm suggesting is that I just want to make sure that it's legal, as we're told that you can't withhold state aid. It's just a data piece. It's a piece of paper report. Perhaps you researched that before we came here, because they brought it up at the meeting, in the hearing.
But that's what they talked about when we were at the department, and this is what we do in other sections of the law.
So that's a no then. You didn't check it. Thank you.
Representative Belcher.
Thank you, Madam Chair. I just wanted to comment a little bit on that, in particular, the whole, whether it's constitutional, unconstitutional. I think it would be on much shakier ground if it was like a penalty, a permanent penalty. But given the argument that this is only being withheld until they're complying with law, therefore the onus is on them to comply with the law, and then they just get the money, I think it's going to be a much more firm ground.
Representative Kluger.
Thank you, Madam Chair. I'm still concerned about the impact on the poorer school districts. And I do think they mentioned that 431 school districts were in compliance with turning, their materials in on time. Was that correct? Did you get that?
That's correct.
Okay, thank you.
That sounds correct.
Thank you.
Representative Murray.
Thank you, Madam Chair. I too hold the same question and curiosity as some of my other members regarding the withholding of adequacy aid. And so I am curious to know what the implications would be to, the students, the taxpayers, the community, if the aid was being withheld and they couldn't then proceed forward with certain things that are required in statute. So I guess I'm trying to understand if that is the appropriate carrot or stick or whatever we're calling it here when we're talking about a penalty of some sort.
Representative Dry.
Thank you. In my notes on this, there's a difference between a grant. We're talking about grant funds, not adequacy funds.
Right. Yeah. Any other comments? Representative Hall?
Chair, just a question. I've got under Nate Green that he said grants must be defined. So that was a problem with this. The amendment fixes that?
Yes, I took the amendment directly from 198.4F, where it states the commissioner shall notify, which is district taxes, penalty for failure to file report. For a school district, city, chartered public school, or public academy shall file reports due under RSA 198.4D. And in Roman numeral 3 of that section, it says the commissioner shall notify the governing body of the school district, city, or chartered public school that all state aid to education shall be withheld until complete and accurate information is submitted. So that's the exact language that I put in the amendment. This all state aid to education, that's the grants that needed to be defined in the underlying bill.
Representative Damon?
Thank you. So, sitting ed funding, adequacy aid is routinely called adequacy grants. So I am not sure that the language as presented here, if it was intended to distinguish between funding that is not state adequacy funding, I don't think that is achieved in this language.
The direction from the department was the language in 198.4F would be adequate for them to uphold what we're requesting in this amendment. And so I inserted it into the amendment.
Any other comments? Seeing none. Madam Clerk, the motion is OTP on the amendment.
Vice Chairman Peternell.
Yes.
Representative Terry.
Yes.
Representative Dry, yes. Representative Belcher.
Yes.
Representative Freeman.
Yes.
Representative Litchfield.
Yes.
Representative McDonald.
Yes.
Representative Tenzar.
Yes.
Representative Nato.
Yes.
Representative Cornell.
No.
Representative Murray.
No.
Representative Woodcock.
No.
Representative Hall.
No.
Representative Damon.
No.
Representative Selig.
Nope.
Representative Kluger.
No.
Representative Snodgrass.
No.
Chairman Noble.
Yes.
10 yeas, 8 nays.
Representative Petronell, do you have another motion?
Yes, thank you. Madam Chair, I move ought to pass as amended on House Bill 1836 as amended by 02026-0648H.
Is there a second?
I'll second that.
Any more discussion?
No, thank you.
Seeing none. Madam Clerk, the motion is OTPA.
Vice Chairman Peternell.
Yes.
Representative Terry.
Yes.
Representative Dry, yes. Representative Belcher.
Yes.
Representative Freeman.
Yes.
Representative Litchfield.
Yes.
Representative McDonald.
Yes.
Representative Tenzar.
Yes.
Representative Nato.
Yes.
Representative Cornell.
Nope.
Representative Murray.
No.
Representative Woodcock.
No.
Representative Hall.
No.
Representative Damon.
No.
Representative Selig.
Nope.
Representative Kluger.
No.
Representative Snodgrass.
No.
Chairman Noble.
Yes.
10 yeas, 8 nays.
Report. Who will write the minority report? Representative Kluger. Okay, so reports, if you could get them to me, it's okay if you're done a couple and just want to send them on. It's better that I have them and I can start trickling them to Karen rather than wait until the last minute. So
By tomorrow afternoon.
yeah, yes, please. Representative Kluger. Okay, and that concludes our House bills.
That means we don't need to meet at all Wednesday, is that correct?
What's that?
We are finished, we don't need to meet Wednesday just to confirm 100%.
Correct. Unless you want to.
No, I'm just confirming, to make sure I have my calendar correct. Don't make plans without consequence.
I looked on what was today. I think we got them all.
Otherwise, I've just been feeling dated.
No, I think you.
Yeah, I went back and reread some.